Notice sufficient. Notice sufficient.
There is no stay.
Stay.
Huh? There is already stay. There is already stay.
But in spite of the order of this on the court, the warrant.
We'll see. Oh, yeah, we'll see.
Beg your pardon, Lordship.
Item 49.
49.
Yes.
Part-
Order to content.
There is interim order. Then wait. The other side is there.
Other side is Vigilance.
Let us see whether they are opposing or not. Let us see if they are opposing or not. When it comes.
Number 72. Item number 72. I pray kindly be taken up one week after.
72. Interim order is there.
No.
Okay.
Pardon to make a mention. The CRLM's application, there was an interim order of stay, my lord. However, now the trial court has issued summons to the accused to answer framing of charge, my lord. On 4/12, any date before that.
We'll see.
The co-accused application has been qualified.
Yes.
The petitioner challenged the order filed by the Jamachi Bakuri Lordship, rejecting the petition filed by the petitioner Lordship for cancellation of the Lordship.
Cancellation of?
Cancellation of bail Lordship.
You want cancellation of bail?
No, Lordship. I want cancellation of bail, but the lower court reject the petition filed by the petitioner Lordship.
Cancellation of bail.
Tomorrow, Lordship, why this is objection?
Not tomorrow. When the trial court rejected?
29/4/2024 Lordship.
We'll see. Not tomorrow.
Lordship.
After 2004, there was no urgency.
No,
And now you,
urgency Lordship, because Lordship.
when your application is rejected by the trial court?
Petition rejected by 29/4/2024 Lordship.
24.
Yes, Lordship. My mistake tomorrow Lordship. 2 times I have Lordship.
24, this has been rejected.
Yes.
We,
No, tomorrow.
it will come.
Tomorrow Lordship.
Not tomorrow. April 2024, it is rejected. Today you are coming overnight. We'll see. Cancellation of envelope. Yes.
I may be pardoned.
1 minute, sir. 1 minute, sir.
Yes.
I may be,
Yes, 1 minute. Yes.
I may be pardoned to make a mention, Lord, it's a fresh admission matter. My petition for discharge has been rejected. The trial court is not
Give
giving.
the memo. Fresh chair. Give the memo. Fresh chair. Yes, Mr. Naik, you are mentioning, sir.
Your Lordships, pardon to mention one CRLMC number 2909 of 2022. Your Lordships, since 10/11/2022, the matter is pending. We have filed an application to obtain the voice sample of the accused, Your Lordships. Here, the name of the accused is one Charchit Mishra. It's Odisha Distributor Limited matter. Lordships, further supplementary charge sheet needs to be filed. Investigation is pending. Your Lordships are categorically told that no further adjournments will be given.
Yes.
So, Your Lordships, whatever may be the decision, please, I would request Your Lordship hear
Give
it.
the memo. We'll see. I'll see adjacently. Okay.
Since 2 years, Your Lordships, it is pending.
The investigation is still going on.
Yes, it is pending, Your Lordships, only for voice samples.
Okay. We'll see.
Yes, Your Lordships.
I may be pardoned, Lordship. Another matter of court number 3, Lordship.
Yes, sir.
I may be pardoned, Lordship.
My lord.
I may be pardoned, Lordship. Another matter of court number 3, Lordship. So fresh admission matter, section 24, application of.
Give me.
My lord.
There are some mentioning.
My lord. Item.
Court number 3. Very urgent matter. Yes, Mr. Pradi.
I'm sorry, my lord. I'm interrupted.
Yes, no
My
problem.
lord, there is one matter is 109. Narsim, I remember the matter of students who are agitating before the Board of Secondary Education.
Yes,
That
yes.
matter, we have filled the deposition copy. And after lunch, I will be appointed. I will not there. Narsim may pass any order because State Council is the stake. He will.
So when the matter is listed,
Today, 109, item 109.
I'll take it up today.
Please,
Come by
yes,
through.
only nothing is there. I have given the deposition. Everybody says, I don't know.
Yes, I'll take it up today. Definitely.
Both the case, one is one petitioner, another case group of boys is there.
Yes, I'll take it up.
Their service are strike, they are not going to join. This is my panic, my lord. That's why. Yes.
Okay.
The threshold is can be caused, my lord. Everybody said that I don't know. The informant said that I don't know.
Okay, I'll
Nothing
take
is,
it. Yes.
Pardon to
in
mention,
single
Your
matter, there is a
Yes,
judgment
yes,
of my
Madam.
lord. We are also citing the same. Yes.
I'll take it up.
Your Lordship,
Yes,
item
yes,
95 in today's supplementary list. I'm assisting senior Manas Mahapatra. So I'm requesting Your Lordship, can this matter be taken up at 2 o'clock? My learned senior is there for the opposite party.
I can't exactly give the time, but I'll definitely try to take it up.
Lordship, the pleadings are over in this matter.
Yes, yes.
Pleadings
I'll
are
take it
over.
up after, I'll just run through the list, then thereafter I'll take it up. Okay?
Obliged.
Run through the list first. Okay.
Obliged.
That's for agreement. Press notice, press address not yet given for.
72. The liquid press is not yet will given. Yes, 100, 114. 140. Weekly 140.
One person, only one person, just. Item one.
Whenever you get the file, you please tell. So that-
I sanction one.
Yes.
Excuse the Lordship.
Yes.
My lord, this was that case where I was inadvertently, it should not appear, Lordship.
Item 1.
I don't know.
Okay.
My lord, in this matter appear for you, Lordship, for interim order to continue. The date has already been fixed to 20th. Lordship, kindly see order number 3.
Where was the interim
Three
order?
was a mistake on my part, therefore I made a mistake, mention. I can
Yes. Interim order dated 7/10/2024 shall continue till next date of hearing.
My lord, in the meantime, for open number 1 and 2, Mr. Procedural Viraji appeared. Now in the meantime, he's joining the state cabinet. I am appearing for open number 1 and 2. I may be
Yes.
recorded number B Marana,
So,
CGC.
Opening 1 and 2. Yes. Yes.
Item two.
I took my lord can.
I will take instruction, my lord, and lordship some of it. I prefer some of it.
Sorry? Some other day. Okay. Seek instruction. Waiting instruction. Yes, sir.
Item three.
Visual also. So here, it's a very peculiar case. The petitioner is a real estate developer.
1 minute, 1 minute.
Yes, sir.
Item 3. No?
Like us, the computer is suffering from brain fade at times.
When the matters are heavy and lawyers are heavy, the computer behaves like that.
Has your lordship ever faced that brain fade issue?
No, heavyweight lawyers comes and the computer also gets scared. Yeah. Morning hours, there's always a problem. Hard copy receipt. Yes, I got it now. You please tell.
Yes, yes. But here, of course, my prayer is very limited.
Yes,
But let me paraphrase the facts a little bit.
yes.
But here I am a real estate developer. I contacted opposite party, the private opposite party. They agreed a MOU was signed. That's on record all. I'm just putting the facts before your lordship. They agreed, they received through RTGS and check 33 lakhs from me
Yes.
to transfer a land and also to develop. Thereafter, they have unilaterally cancelled the MOU. Now, I approach or to center the law.
Yes.
The criminal law set to motion. Charge sheet has been filed. They approach this
Who
honorable
is
court.
appearing for opposite party number? You are it.
They approach this honorable court for anticipatory bail. Now, that's on record I have also filed. This honorable court said that out of the 33 lakh admitted dues, you deposit 20 lakh with interest within certain period, go on bail, pay the rest 13 lakh with interest within that much of period, 1 month or something like that. That they have done, they have been released on bail. Now,
They means who?
my lord,
The directors.
the opposite party number 2 particularly.
Opposite party?
Number 2. Kalyan Kumar Barik.
Okay,
These 3 and 4 are the landowners.
okay. You are the developer, you are the developer.
I am the developer. My lord, I paid him money. He will provide me the land and took up certain development also. So this is the intra-party developer.
Yes.
We both are in same business.
Who has given this FIR?
Now the present petitioner has given the FIR.
Okay. Now you want the money back?
No, the money has been
33 lakhs and
33 lakhs with interest has been deposited in the court, my lord.
what do you want? You want that money?
Yes, ma'am.
As per direction of this Hon'Ble Court, my lord.
Oh, yes, of course. And you volunteered to get that bail or from being not detained. You have volunteered and deposited.
But ultimately it is a money transaction.
Money transaction.
You get back your money and file a quasi petition and quasi take the money.
Provided they are agreed.
What do you want? You in any case you have to pay the money. You have taken. You are the landlord.
My lord, petitioner preferred criminal investigation number 835 of 2023 before this Hon'Ble Court paid 51 million and
Yes.
and this Hon'Ble Court not inclined and the same was withdrawn with a prayer to seek appropriate remedies as may be available in accordance with the law.
Very fair.
Yes.
Very fair.
And
But thereafter,
bail order was granted. The opposite party number 2 was condition precedent, my lord. Cash security was deposited in the nationalized bank in the fixed deposit carrying interest bearing account.
yes.
Now they are prepared for expedient trial. Case is not ready for trial.
No, that you can
Forget everything. Now you want to. You have paid back the money. It is deposited in the bank. Why don't you settle? Finish it up.
Settle.
You want to face the trial only.
I have
And
no
thereafter,
instruction.
you will take back the money, you think, after acquittal.
I have no instruction, my lord.
No, that's what I'm saying. You explore the possibility because in any case, you are the landlord. You have taken the money, given the land to the
He is not
developer.
the landlord. He is the person.
You are interested in your money.
Yes, only. I don't see that
That money has already been deposited.
deposited.
So therefore, why don't you explore a possibility? Shall I send it to mediation? Try, if happens, happens.
Yes.
And take back money.
I was in his instruction, my lord.
At 2 o'clock, you seek instruction.
My lord.
I'll take it up at 2 o'clock.
No,
Seek
my-
instruction. I'll send it to mediation.
It won't sir case, my lord.
Bhubaneswar
Local council.
I'll send it to mediation. I'm not saying I'll not pass the matter. Anything can happen. If you are not agreeing, then I'll decide on merits, whatever.
Yes, yes.
Explore a possibility since it has gone from your pocket already. It is lying in the bank. Better pay them and finish it up. They are the builder. They may agree for a little lesser than what you have already paid. What you have already deposited.
Yes.
Or the bail condition you have already deposited. It is a matter of only exploring a possibility of settlement. That's all.
Unfortunately, we have
That's
this
how I will take instruction, my lord.
pass over thought ना
पास हो नहीं आज ही पास होना है
खाली
कल नहीं
खाली नहीं
legally बाहर
नहीं, if tomorrow it can be done today also.
day after tomorrow.
we have taken special messenger notice with the hope that we will
That's the idea. Special messenger. Then I'll put it day after.
Yes.
But you persuade your client
Yes, ma'am.
and they may agree for a little lesser than what you have already deposited.
How there will be prejudice or gainer in not
Nothing.
coming.
Nobody is gainer here. Nobody is gainer here. Better that you stop the entire. Yes.
At the
114.
at this same stage, President.
Yes, yes.
Grateful.
Yes. 114 weekly cut off.
Father and mother both are HIV patient, mother died.
114. Weekly. This is the regular bail application.
Regular bill.
What I'll do is I'll allow for a month.
For a month.
A regular bail application you
Consider my lord.
no, you apply there.
I have applied already as per your lordship.
I once again 1 month you will get free time, go and seek with the lawyer. Madam, petitioner has moved a application. I'll just see. What are the offences?
302.
Oh, If you get longer time, then you commit one more murder. That's the problem.
HIV ବାପା ବି HIV
Petitioner has moved the present application for grant of interim bail. Interim bail to attend the customary rituals of his interim bail. Interim bail. On the ground that his mother has expired on 20th/11/2024, and 21 he wants to attend the customary rituals. A notice was issued to the State Council, and who has obtained the instruction from the IIC Chandili PS, and the instruction dated 23/11/2024 reads as under. Regarding you had to be aforementioned, the petitioner is the trial court is directed to release the petitioner on interim bail for a period of 6 weeks. For a period of 6 weeks on the condition as the patent proper. Insofar as the regular bail application is concerned, the petitioner seeks to withdraw this petition to renew the bail plea before the trial court on the changing circumstances. With this liberty, the BLAPL number so and so is disposed of with the liberty as prayer.
Certificate copy in course of
Just by evening he has to come out. That's yes.
Item 4. Please, my lords.
Yes, sir.
This is the cognizance order under challenge.
Yes.
Under second.
Wanted to take the instructions.
So I have given your lordships the judgment of this honorable court.
I know. What do you want to say, sir?
Well, I have not been able to get the instruction. It's not
This
clear.
already covered. And this
It's already covered. I gave because for reasons that you have you wanted to. That's the reason I kept it Tuesday.
the second way was more destructive and disruptive than the present. The financial year is 21-22. So this is during.
What is the range of delay?
The range of delay is 84 days to 1 day. And here your lordships have dealt with delays beyond the 245 days. And their own circular says not.
And this is COVID period.
This is COVID, the second phase. And
Second phase.
so far as the Sri Metallics is concerned, your lordships have also discussed about the circular of the government, of the department. Like the lordship kindly take up that Sri Metallics have given your lordship that order.
Yes, that I know.
There your lordship.
But now there is a recent circular which Mr. K has shown me. That circular says that they have made it easier for compounding. So therefore everybody has to go there.
This is one part. So your lordships have analyzed that my case comes under reasonable cause. The 270.
That's right, you have to go.
And the reasonable cause not is well known. And your lordships have specifically held that no trial is necessary to establish that there was a reasonable cause for the default.
What do you say?
And their own.
These are COVID period cases.
And if it is
Special attention to be given, and second phase COVID.
more destructive, than the first phase. And the entire.
I'll pass record the presence of both criminal counsel for the.
My submission may be recorded as I have.
Yes, I record the opposition also.
I've given the 3 judgments of this honorable court.
Hard copy, yes,
I got hard copy.
what is it?
Along with the honorable Supreme Court.
Yes. Okay. Okay, sir. Thank you.
My learned friend, Mr. A. N. Rai and Mr. Jena, they are appearing along with me.
Yes, in Rai Jana.
HB Jena and.
In writing,
I'll give it.
evidence. You also please, both for the evidence. Yes. But the other matter which I have reserved, he has argued, I want to take into consideration the circular also, recent circular, how to deal with the circular. But this is the case where COVID period, they are directly covered by. Yes.
Directly covered by this reasonable cause, you know.
A reasonable cause that. I think 277 capital A.
No, that is not
278 capital.
No, 278
capital A.
278. double A, my lords.
Double A.
278 double A, a reasonable cause. And this is one of the.
Generally, what happens is the reasonable cause is generally shown by the SSC, but the problem is the department don't read it at all. File a complaint.
Unfortunately, my lord,
difficult.
in this 279 order, my lords, they don't deal with the COVID part at all.
That's the problem.
Even though I've specifically taken a ground.
That's the whole difficulty. Casually, the same format they file. And thereafter, these people face a lot of problem to defend.
And circulars, my lord, will never be binding on your lordship.
Correct. Absolutely.
Much obliged.
Thank you.
I'll give the other names of my adjudicates.
Item 5. Item 5, Lordship, paper pass.
Password? Yes.
Item 6.
Item 6, I am for the opposite party wife.
Yes, madam.
You will kindly have a glance. Order dated 9/10/2024. Passed by this honorable court. 9/10/2024.
Yes.
Your lordship, I pray for an adjournment for the petitioner, your lordship.
No adjournment, my lord. Without notice, he has got the blanket order of interim order. LPW was challenged for area maintenance of near about 5 lakhs.
So the MW has been issued without issuing any notice or something?
No, notice was issued. He has not appeared. He was set ex parte.
There is no coercive action.
No coercive action.
You are for the opposite
I have
parties.
appeared
What do you want?
Adjournment, your lordship.
Huh?
Adjournment can be.
No. You have taken interim order ex parte and she has entered appearance opposing. How can I give?
My senior will argue.
On my
I'll pass it over if you want. I'll pass it over.
We can take it on Thursday.
No. You can't decide the date. We have other things to attend. You can't decide the date.
Any day within this week. Tomorrow.
We can't because it's very difficult to get the matter listed. Getting a slot is very difficult. We are adjusting so much to get the slot adjusted. And once it is listed, you can't ask for adjournment. If you ask for adjournment, it will go to February.
My mention matter has
But
been.
there is an opposition. What to do? Generally, adjourn it. But what to do? There is an opposition. And execution proceeding of the wife.
Yes.
Any maintenance proceeding is stayed.
Yes. It's not stayed, your lordship, no course of action.
With the
No coordination is stayed. You don't pay the maintenance. How the she will survive?
Yes.
Mother and son.
What is the amount awarded?
Awarded 15,000 per month.
You pay monthly maintenance and the stay will continue. Subject to paying monthly maintenance. You can't leave them to, serve. You make the money. So insofar as the arrear is concerned, the execution proceeding will take care of that. But I'll modify the interim order to the extent that you keep on paying monthly maintenance.
So I'll take instructions.
What instruction you have to pay? If their wife and children, your wife and your children,
Yes,
you will leave them to starve.
The present petitioner also has some financial
What is their wife and children?
Yes, sir.
You are married. Are you disputing that she is not your wife?
No, not disputing.
Your child is also there. How will they survive?
Yes, sir.
15,000 rupees, 15,000.
15,000.
You have to pay.
5 lakhs is arrear, my lord.
Area forget. Area we will see. Where from will get area? Area you don't pay right now. We will see area. At least monthly payment you should continue paying.
Yes,
otherwise, how they will survive?
I'll take instruction passable.
No, password I can do. Subject to paying monthly maintenance, and the stay will continue, and we'll decide it later on. Okay.
Obliged.
Okay.
Item 7.
Please, Your Lordship. Your Lordship, I'm on behalf of Mr. S. Chinna. Lordship, as per my instructions, there's a MSc application pending before the learned court below. Lordship, may kindly give an adjournment.
What is application?
Lordship, the MSc application for insurance. This is a case wherein an accident had occurred.
What do you want in this proceeding, madam?
Your Lordship, may kindly give an adjournment. We proceed according to the proceedings before the court below.
He says MSCT case is pending. So it will have a bearing there. So therefore, perhaps he wants an adjournment.
Yes,
Please it in the February. You prosecute MSCT. You must get compensation there. Okay.
My Lordship, I'm for the petitioner.
It's all right. I'll simply adjourn on
Yes.
the request. Adjourn on the request. Okay.
Item 8.
My lord, dispute between husband and wife. I am the husband. After 18 years of marriage, she has filed a 498.
I'll issue notice. Huh? Matrimonial dispute.
Matrimonial.
Huh?
Both after 18 years of marriage,
What?
admittedly they have got disputes. And my lord will go through the death chat. You see several cases.
Several cases. Let us call her and see we can settle the issue. That's the only thing one can do.
Just 1 minute. She said last 13 thing 2020 before COVID. She stayed there. There was no dispute by then. तापरे हस्बैंड तार पठेला तीनटा छुआ आसले स्वामी स्त्री आ दुईटा छुआ आसले दे वांट ताको जिबा लागि 30 तारिख पठेला तीनटा प्लेन टिकट टू दिल्ली हस्बैंड आई स्टे एट दिल्ली एंड दे लास्ट रिलेटेड एट दिल्ली में स्वामी पढुले किछोट गला पढियासो दे डिपार्टमेंट एंड thereafter much after action put at it just
I am issuing notice by
legal notice potentially the nature legal
letter come
since I did not agree
we'll see just file the requisite file the requisite and move application before trial court. Yes. Before trial court if it is at what stage?
It is just lying. GR case has been registered.
Investigation is going on.
No.
GR case. Yes. No, then cognizance has been taken. Cognizance has been taken.
Has not been taken.
Then wait. You move application there. Yes. Trial court. If it is taken up, move an application for adjournment saying that this matter is pending before Supreme High Court. Yes. Next. That will be. Yes.
Proceeding is under telling
Okay.
The arising out of a civil dispute. FIR is under section 447, 427, 506 or 34.
Yes.
But charge sheet has been served under section 506 or 34.
506, 34.
34, ma'am.
Okay.
And if you also have a glance to the FIR as well as the charge sheet and other part, that
what are the allegations?
Allegation, that civil case is pending with regard to a land dispute, that people have entered to their land.
What are the allegations that I see?
Let me know.
Allegation is also 35 in charge. There is a common page. That these people, in spite of the order matter, he has entered in their premises and agreed with them. And they are continuing.
No, 506 only.
Only 506. My only submission is that we not.
I'll issue notice. Let 506 unaccepted. Okay. Issue notice. Party करते थे नहीं. That's the whole difficulty with you people.
I think I'm ready for it. People also allow that I'll file it. Maybe I'll get it.
We are minimum thing once a month.
That will meet. I'll come to the mistake for that.
You implead or what to do? The counsel for the petitioner seeks to implead the informant as opposite party number 2 during the course of the day. If the informant is impleaded as opposite party number 2, issue notice to the newly impleaded opposite party number 2.
Also allow I'll make it party.
There is nothing in there. No paper is there. Where will you do? That's the otherwise generally I used to give the hard copy of that thing. That's the problem. Now prepare a memo of parties and file you immediately. So that notice can be issued. Yes.
In this case, the legal question
9, item 9. Yes.
I am challenging the order taking cognizance. The legal question involving this case. By the Inaction proceeding pending for the same self-conviction, FIR is maintainable or
maintainable.
The matter has been referred to the Supreme Court. After Supreme Court, referred to the larger bill.
If a composite FIR is the composite complaint is filed, then the situation is that.
Composite.
Is it a composite one separate?
First, she filed one NIACT case.
I know what is let us see.
Which
paragraph?
Last paragraph, no?
Last paragraph. Yeah.
And this was the last hearing in September. The
Delegation was house. If you notice, petition seeking quashing of for the order dated 11/5/2023 passed by learned ATJ, Denkanal and GR case number 736 of 2022, arising out of the PS town PS case number 332 of 2022, whereby cognizance of offences punishable under section 420, 468, 471, 406 IPC has been taken against the petitioner. Then counsel for the petitioner submits that for the self-same on the self-same allegation, petitioner has been prosecuted for offences. Prosecution petitioner has been prosecuted for the offences punishable under section 138 NI Act. He relies upon the judgment of the Honorable Supreme Court reported in reported in so and so. By relying upon the para 12 of the said judgment, which reads as under. He relied upon the para 12 of the said judgment. Para 12. In view of the aforementioned judgment, he submits that for the self-same allegation, petitioner cannot be prosecuted twice. Twice, and he submits that he is covered by the judgment of this Supreme Court, which has already been referred to in the argument. Issue notice to opposite party number opposite party. Opposite party number 2, Mr. Jana accepts notice, written so and so, and the further proceeding in so and so state. Yes.
11.
But there is a difference. But you have to deal with that. If it is a composite, if it is a composite complaint, cognizance of both 420, 468, 471, along with 138
that is not composite. One is Warrantpur.
It is somewhere else.
One is Warrantpur, one is Dhenkanal.
For that matter, not only this petitioner, he has issued 3-4 checks, and all has been bounced. In this petitioner and the one by his father, and that the investigation is going on.
No. They cannot tell that.
Yes, one minute.
What is
But in this case, what? In this case, cognizance has already been taken. But in so far as the other cases are, you carry on the investigation. I'm not saying. No, the other cases.
Other cases, charge sheet is Olga Sadar, enact other Nothala.
Yes. Call proceeding. Call proceeding. Yes.
11.
Multiple lordship. Dear my lord, I have challenged the order of taking cognizance by adding section 109 against the wife of the main principal accused. A lot of decisions my lordship has also passed, also the apex court, but it is something different, my lord. all those cases, my lordship observed that those wife of the accused persons were housewife. Here, the present petitioner is a government servant, and she is drawing salaries since 1997. So, how 109 will be applicable? Either separate proceeding can be initiated for disposition asset against her as well as the husband. But why 109 will be added to this petition? This is the sole grievance before my lordship.
You say that I have committed a large graver offence, so therefore I am subjected to a minor offence.
If my lordship observe that yes, there I have accumulated disposition of asset. Being a government servant, then I am subject to PCR.
She's the wife. Second wife of the.
He says that she herself is a government servant. If at all is there, I have not evaded my husband. I might have acquired
asset, and for that purpose, I should be prosecuted for second money.
Yes, that's what he says.
So for prosecution case is concerned, even if he has not filed the charge sheet, the cognizance is taken. If the prosecution case is she has abated her husband, then 109 will be added. She may be a public servant or whatever she may be.
What are the for abatement allegations?
The case
merely saying abatement will not make abatement unless she is working herself as a government servant. You can prosecute her independently.
She is claiming that I have income from salary and other sources also. And by that process, there are lots of assets, movable, immovable assets has been acquired in her name.
In her name, then prosecute her separately. Register a case. Yes, sir.
If that will be
Why are you taking aid of 109?
Means that since there, if the prosecution case is there, she is intentionally aiding her husband, and the plea taken by her.
Show me where you said.
The he has to give the charge sheet. He has not
File,
given the
well,
charge sheet.
Sir, asset, I have
file charge sheet. My lord. When counsel for the petition seeks to file additional documents.
Judgment is also there. If husband and wife both are residing in a common mess jointly at this stage, that cannot be segregated.
True. But the problem is in the charge sheet, you people generally say that he has or she has aided without saying anything. In what manner aided? Nothing is there except one sentence somewhere. Now I am sure 100% sure. One sentence somewhere she has aided the husband.
Only this is the only line.
What are the evidence? How he has aided? Nothing. And 109 is there.
Sources of income achi.
That's what he says. Income achi, disproportionate achi. I have not aided I am independent. I have committed my offence separately.
It will be segregated and a separate case will be registered.
That is your problem.
If assets counts that is the
joint. That is your problem.
That is joint property. Then this will be added.
That is your problem. He says that no 109 at least. I am getting an additional document. I least after 1 week. After 1 week. Huh? Yes. Just check it up. And now you are wiser. You know what to do. Yes.
May I please? Let me arrest offences under section 419, 420, 467, 468, 471, 494, 120B, 34. My lord, the present petitioner is the wife of a person who is alleged to have married several times thereafter. And here
thereafter means after separating from you.
No. I am continuing as a wife. During the subsistence of this marriage, during subsistence of an earlier marriage, he has married me. During the subsistence of this marriage, he has married several others. Now the allegation against the accused is, after marrying them, getting into nuptial ties, he has siphoned off some money from each of the wives. Somebody has paid 8 lakhs, some 10 lakhs to the accused. Now, my lord, I am the wife of the main accused, and allegation, if your lordship sees, I will point out pinpointed lines.
The second or third wife might have made allegation against you. That my
no, mo against allegation hala se kichi property mo chua jo mane minor माने जोटा मो हस्बैंड माने
You aided your husband to
हाँ माने एटा भी
extract.
कहैनी से कहिचन जे मो नारे प्रॉपर्टी अक्यूज करिछि माने अक्यूज किछि प्रॉपर्टी अक्वायर करछि किंतु एई एफआईआर इफ योर लॉर्डशिप इज माइनर छुआ को नारे हेछि जे मो छुआ आई एडमिट बट फॉर दैट माय लॉर्ड माय सबमिशंस आर 419 467 468 तो इंग्रेडिएंट गुडा आदर आसीबो नाही. So, my lord, at best, considering for a moment but not admitting, there may be a case for 120B at best. But my lord, my case is that the allegations, if your lordship sees a bare perusal of the FIR even, that ascribes specific roles to persons who have been made accused. And against me, the only allegation is, my lord, your lordship may see, may I take a
How much you have taken from this lady?
Nothing. I have.
Now your husband.
Husband has taken 11,08,760.
And that is invested in the name of you and your.
No. That I am showing that. My lord, may I take your lordship to page 19?
Come to page 36.
36.
Read it.
My lord.
Read it, the relevant part.
My lord.
Read the relevant part.
My lord, the relevant part is at page 37. In fact.
Yes, read it.
Further stated that the alleged accused person Kamala Tirki, alias Swain, 54, wife of Ramesh Chandra Swain, daughter of Manu.
Who is the real culprit, according to you? His husband. Her husband.
Yes, he is my husband. Address such and such, Chhiya Nagar, PS, Phulpur district, Prayagraj, Uttar Pradesh. I live in a separate residence altogether, my lord. It is the admitted case of the police investigation and Uttar Pradesh, and also accompanied with Ramesh Chandra Swain, Smita Behura making plan to cheating me. But your lordship, in the same statement, if your lordship sees, there are specific roles ascribed to others, that he went there, he went along with it. Those are all theirs against specific persons. The only allegation against me is that to bring in rope in the petitioner, that she also accompanied in cheating. So, my lord, that's my.
I am in the similar case. Here is a case, this husband of this petitioner, my lord, and this petitioner, I jumped out a plan. Yes. There is a racket, my lord. Yes. The husband of the petitioner got married to several persons.
You get the money and the investor.
Yes. And that money was kept in the name of this petitioner. And at this time of cognizance, this is the, my lord, very beginning of the, my lord, initial stage of the proceeding.
Yes.
And prima facie case is well made up, because they have checked out that the money transaction has been made. Petitioner, he had used the money to purchase something in her name and also in the name of
what is your husband doing?
He has said that he is a doctor, but in fact he is not a doctor, as it appears. My lord, you
don't know about your husband
because
who's getting money from different sources and
the submission is made that it is transferred to my account. It has not been done. Your lordship.
Those things can be appreciated in the right place. When you are long and short of your case is, the offences which are cognizance of which has been taken is not made out against you.
Not made out against me to the extent of 419.
That's right. Then you argue those things at the stage of framing of charge.
Well, only one line I'll show. After that, your lordship my lord may come to page 18.
18, yes.
My lord, submission was made that some amount has been transferred to my account. Your lordship may see categorically whose account it is transferred has been specified. And the next page, page 19, there are two accounts to which it has been transferred. Those are minor accounts. It is not my account, my lord.
You are still staying with your husband?
No. My lord, may see, it is their case that I live in Uttar Pradesh.
But then, obviously, Uttar Pradesh, you are staying separately. He earns money, going different places, pretending to marry with women, extract money, and bringing that money and investing through you.
Husband of the president petitioner lordship is married for 10 times to lordship. The president is the second wife.
He is accomplice. He is accomplice. Yes, I understand. Write on, you write on. Petitioner
17 and 20
order dated 22/7/2022, whereby cognizance of offences punishable under section 419, 420, 467, 468, 471, 494, 120B and oblique 34 IPC has been taken against petitioner along with the co-accused person. And counsel for the petitioner submits that even if the facts narrated in the charge sheet and document collected by the police, which forms part of the charge sheet, is taken its face value. No case against the petitioner for various offences, cognizance of which has been taken is made out against her. Therefore, he attains the order of cognizance in the present petition. I am not inclined to entertain this petition at this stage. However, liberty is granted to the petitioner to urge all the points before the court below at the time of framing of charges. By
17 and 20 also.
Same petitioner, similar FIRs.
Another word.
No, same valid. Petitioners are same. Petitioner is same.
But
I am only giving a gateway to come to this court once again. That's all.
17 and 20.
Beyond that, nothing will happen.
No, I understand.
21.
17?
And
20.
17 and 20, same out.
Published.
But you argued very well.
Published.
Yes.
May it please, Your Lordship. My Lord, in item number 30, I am on behalf of Mr. Mahapatra.
Yes.
In this case, my Lord, the petitioner preferred a CRMC wherein he prayed for modification of condition 1 and 2, that is at page number 12.
12,
my Lord, 1, 2, where the learned court below stated, she shall personally appear before the court on each state of posting of the case without fail.
2. Condition number 2.
Condition 1 and 2, so do 1 and 2. Because, my Lord, the lady
personally before the court.
The matter is pending before the special judge Vigilance, Jaipur, my Lord.
Even undertaking before the court that we shall attend before the court. Yes.
The matter is pending before special judge Vigilance, Jaipur, my Lord. And the lady belongs to, now she is residing at Chandaka. And the permanent resident of the lady is Balasur, my Lord. As and when required, the lady will appear. That is modification of conditions.
This undertaking has been mentioned.
On that, my Lord, thereafter.
His undertaking.
But I tell you one thing. No, there is a legal issue involved in this case. I don't know whether he read it or not. If he is entitled to a procedure, the CRPC has given the statutory protection in different stages. What statutory rights rather? By way of a condition imposed in a bail, can you take it away?
317, the advantage she can take.
317, 205, all these are the statutory procedure that right is bestowed upon an accused. By way of a condition imposed in a bail, can you take away those?
The thing is that can the Lord court below.
He might have given concession or whatever.
Lord court below has considered relying on the order.
I'll simply say, imposition of this condition will not preclude him to resort to the remedy available to him under CRPC.
Yes, ma'am.
This is what I'll say.
Yes, sir.
High Court positively says that.
Whatever, maybe, but according to me, but these are the remedy available to him. Na? Statutory remedies, you can't take it.
Record shows, see, the Lord court below is also allowing 370.
Generally, they do. Petition is agreed by the condition number 1 and 2. The condition number 1 and 2 at page 12. 2 likha hai 1 and 2. Imposed by the court below while enlarging the petitioner on bail. Mr. Sahul and counsel for the petitioner submits that although the imposition of condition is on the basis of the concession made by the counsel for the petitioner at the time of submission, at the time when the submission was made for grant of bail, but that shall not preclude the statutory entitlement flowing from the court or to resort to the remedies available to him. Regard being had to the submission, it is made clear that the imposition of condition, aforementioned condition, shall not preclude the petitioner from resorting to the remedies available to him, statutory remedies available to him under the code. With this clarification,
But
I'm not saying I'm not saying anything like that. Yes. You should have read it and come.
well, 370.
You are always preparing on facts only. To find out some law points, find out something. That is how you can, you should have come with this kind of. This is the occasion. You must. Yes.
Beg pardon.
40.
May it please, madam.
Not on page 49.
Yes, 40.
9. Annexure 3. I'm sorry, my friend. Bad throat today.
Use me for that.
Otherwise, also you are always mild
That's
and pleasant at the same time.
Grateful.
Yes.
Grateful. 294, 354A, 506.
Yes.
Lordship may now come to, for a second minute, so Lordship may kindly come to page 56, annexure 5.
Yes.
My submission, my lord, is a service dispute. Advance was taken, was not returned. Then the employee comes back, lady employee, comes back and wants to gives a resignation. So therefore, as per my lord's official formalities, unless the advances are cleared, they will not give a release order. So they refuse to give a release order, naturally because they are bound by the rules of the bank. Now this lady threatens, I'll file a case against you, I'll go to the police and all that, managers should drag them. In their apprehension, they will go and lodge a complaint to the police that she might come.
Is there any Bishaka proceeding taken out?
No, nothing. All these statements are in our favor. I don't know how my charge sheet could have been filed in this. Your lordship, this was page 56. The company entire thing narration, the whole thing is narration is that how she was not.
I'll issue notice 354 and all. Why? Maybe some unpleasant thing has happened in the office.
That may be a service dispute. How can you snowball into a criminal case? And my lord, even more, the HR manager is in Bombay, that another lady, 354 against non-application of mine, my lord.
Anyway, I'll just issue notice, let us see. I'll issue notice to the opposite party. Letter cup.
And some form of protection.
You must be on the bail and all.
No, I am absolutely bail.
You are
proceedings in the trial. Why should I go to the trial court?
Trial court is going. You move application, huh? Let's move application for adjournment.
Lordship, may state letter come, matter can be.
What do you say? I'll say
completely it's a manifest. Manifest.
Aggravating these kind of situations neither good for them nor good for a lady.
He is working somewhere else.
He must be working somewhere else. Yes. 354. Some kind of misunderstanding has taken place in the office. He made allegations against the HR manager and everybody. Why to precipitate it? I'll stay the proceeding. I'll stay.
Grateful.
Stay. Better that you persuade her and finish it up.
Hello.
We have been pursuing it.
We have been pursuing it.
But she's not ready.
Hellbent too.
Time will heal everything. Wait for some time. She should come out. Come down from her.
This might cool down the tempers. Interim order of your lordship might cool the tempers.
But this is not even in the interest of her.
She is not in her interest.
She has a career ahead. Unnecessary.
She will be also called for statement and all that.
It's not required.
Grateful. Urgent copy.
50.
Maintenance.
60. I just don't entertain in between, but ma'am is there, so therefore she will be waiting unnecessary. 660. Okay, 60. 6. Okay. Just now I entered, henceforth never mention it in between. Okay.
Copy was not solved.
Okay. So and so entered appearance for opposite party number 2. The petitioner is directed to supply the copy of the petition. Copy of the petition. Learned counsel for the opposite party submits that the interim order which has been passed on 9/10/2024 while issuing notice to her is hurting her because neither she nor the child is getting regular maintenance from the petitioner. In that view of the matter, she seeks a variation of the interim order. I'm completely in agreement with the submission made by the counsel for the opposite party number 2. Therefore, the interim order made on 9/10/2024 is modified to the extent that the execution proceeding in execution case number 2 of 2024 shall remain stayed till further orders, subject to the petitioner keep regularly paying the monthly maintenance already awarded in favor of the opposite party number 2 and her son.
1 and 2.
1 and 2 opposite parties. With this variation of interim order, the matter is adjourned to so and so day.
A date may be fixed.
Date will be fixed.
I will file the objection.
You file. The opposite parties are at liberty to file objection in the meantime. Okay.
The petitioner will be allowed to file an appeal.
Appeal against? You have a right to file appeal. Why should I tell you file or not? Shall I tell that against my order, so you go to somewhere else? Then you have a right. You go. Who stops you?
Okay.
Keep on litigating. Pay your wife and finish it up. You file appeal and all. You don't want to pay to your wife and son. You pay. Yes.
Okay.
Yes, sir.
Item 15, pass over, my lord.
Pass over.
15. 15.
16.
16.
Pass over.
18.
Item 18, may I pray to accept?
Withdraw. Yes.
No, my lords, to accept. Item 18 to accept.
You, acha. Urgent on requested. Here.
19.
19, that's over, my lord. Yes, that's over.
Pass over.
My lord.
21.
Well, Lord, in this application, the petitioner has challenged the order of cognizance taken for the second time of the offences. It's covered by this court's judgment, which was passed relying on the judgment of the appellate.
Second time?
Second time, my lord, in shape of a protest petition, charge sheet was filed on the FIR and cognizance was taken. Thereafter, a complaint case was filed in the shape of a protest petition, upon which again cognizance has been taken.
For different offence or same offence?
Some more offences have been added. But that cannot be there. This is the judgment. Para 9 will submitted.
Para 9?
Para 9 is relevant, my lord. It has been.
Yes. Yes. Law is fairly well settled, but cognizance of the people one.
For additional offense, my lord, or separate provision is there in the purpose.
Yes. What are you challenging the subsequent cognizance?
My lord, the subsequent order of cognizance and quashing of the proceeding itself.
Why is you
cognizance was taken and thereafter the
quashing cognizance order may go, but in the charge stage it can be added. That's what the judgment of
my lord. So cognizance has been taken in.
My learned senior has filed an order dated 5/7/2024, when which the learned trial court has rejected the petition for framing of discharge also. Discharge petition has been rejected. Now, what happened now in the 3 months already been elapsed in the meantime, whether the learned trial court has already framed the charge or not. That
you have come against the discharge.
Yes, my lord, that was filed. That was rejected. But my point is, if
no, have you challenged that order?
No, I have not challenged.
Then,
Lord, my submission would be.
No, your submission I understood. But the problem is, para 9 you have seen. Para 9 has something else to say. It says that cognizance can't be taken, but at the stage of framing of charges, it can be added or subtracted.
That is
what the
that
judgment.
could have been done in the original case.
Then you have resorted to moving an application under section 227 whatever. And which has been rejected. What to do?
Not inclined to enter.
You should have approached the court prior to that.
No, my lord.
Or you challenge that order.
My lord,
saying that Cognizance
if the order of cognizance is bad, the case cannot proceed, my lord.
That's time you should have taken.
And these
No, Cognizance, if the order of cognizance is bad, that time you could have challenged, one can understand. If the charge has been framed, then this judgment is not, rather it goes against you.
Now, my lord, simultaneously two cases are running.
No, two cases now.
One is one on the basis of the FIR. A GR case has been registered. This is a complaint case, my lord.
No, it's a protest petition.
My lord?
Protest petition in the same.
No, my lord. Cognizance has been taken in a.
You show me, charge has been framed twice. Show me. Show me whether charge has been framed twice.
I'll show you, my lord. I will see.
What? So charge
cannot be framed twice. GR case, my lord. Now there are two cases.
No, you show me the charge has been framed twice.
My charge has been framed in this complaint case.
What about the other?
That I have to take instruction.
That's the
So may call it any other day. I'll take instruction.
On request, yes. Request, yes.
22.
May it please, Mr. Lordship.
Yes, sir. Lordship, in this case, the petitioner is a 62-year-old citizen. My father-in-law, in a matrimonial dispute, has challenged the passing of affairs.
Issue notice written about. Matrimonial dispute 498.
Arranging a complaint case, your lordship.
No, it's in jail case.
Notice has been issued already.
The fact is that the petitioner's family is involved in long-standing property dispute with relatives, including the complainant. The complainant lost Pipili PS case number 334 of 2020 on 27th October 2020 as a counter to an earlier FIR, Pipili PS case number 204 of 2020, filed by petitioner's mother. Petitioner's name was maliciously included in FIR.
What is this case? What is this case?
My lord, charge sheet has filed, but the name of petitioner is not there. But when, as he is a BDS profession, when he approached to organizations, they told that your name is in FIR, so we cannot accept your application.
If there is charge sheet has not been filed against you, you are free.
Here's the case, complaint case, your lordship. There is the allegation against the present petitioner, lordship.
But charge sheet has been filed without including
my lordship, but since 2020, my learned friend submission is taken to be correct, then that charge sheet is filed in 2020, your lordship.
If the charge sheet's name is not there, then what? How can you maintain this petition?
But charge sheet has been filed not in this case, your lordship. My expert assumption also have not received the entire case diary. Lordship,
my lord, organizations are told that either you have to approach before us after removing the name from the FIR, otherwise after disposal of the case, which affected his career severely.
You tell me in PPL PS case number 334 of 2020, yes. Charge sheet has been filed?
Yes, your lordship.
Whether this petitioner is accused or not.
In that case, your lordship, here is the case, the present petitioner is the Dr. Sambit Kumar Mahapatra, lordship. But here is in the charge sheet 334 in PPL PS number 334, the Sambit Kumar Mahapatra is not arrayed to be as an accused, your lordship, in this case.
Then,
your lordship, can be right. But my respect submission, lordship, here is a case, again, the alleging out of complaint case, your lordship. That complaint case is annexure.
That's not the prayer. Come to the prayer.
Yes,
prayer he says, was this proceeding? That is FIR number so and so, so and so. If he is not an accused, where is the question of quashing?
Yes, your lord doesn't arise, your lordship, not at all arise, your lordship.
Yes, Mr. Manti, what do you want to say? See, you are seeking quashing of the FIR and the consequential proceeding. And this FIR was investigated, charge sheet has been filed where you are not made an accused.
Due to organizational allegation, I want to remove name of petitioner from FIR, my lord, because organization not ready to
understand. No, I can't do that. I can't do that. Organization people may say whatever. How does it make difference to me? If your name has already been removed by the police, you need an order, court order. What is this? I'll record it. See, what I'll do is I'll record your submission and dispose of the petition, and you show this order to the authority. You say that now.
My lord.
High Court has also endorsed this view. Okay.
My lord. Obliged, my lord.
That's better. Okay. Petitioner is passing for the FIR in PPL PS case number 334 of 2020. 2020. After investigation, the 2020 dated, pura likho, nahi to he will not get the benefit. Dated 27/10/2020. After investigation, charge sheet has been filed on.
Charge sheet, Your Lordship. That is on 31/3/2021, Your Lordship.
31/3/2021. See, your first FIR offenses will lick the charge sheet has been filed. After investigation, charge sheet has been filed on side. In the charge sheet, the present petitioner has not been arraigned as an accused. The petitioner, hence, there is no cause of action subsist in his case to assail the FIR. FIR as mentioned above. Hence, no interference is called for in the present case, since the petitioner is not even an accused in the FIR in the charge sheet, germinating out of the FIR as mentioned above. Hence, the petition is disposed of. Yes, this clarificatory thing will help you. You show it to your authority. Yes.
My
Lordship. Well, this petition filed for quashing of the proceeding, my lord. An offense under section 420 IPC, my lord.
Yes.
And the allegation is that the petitioner had opened a jewelry shop in the house of the elder brother of the informant, my lord. There, my lord, for the purpose of the marriage of the informant, he had gave a cash of rupees 1,59,000 to the petitioner to purchase gold ornaments. It is alleged that thereafter the petitioner closed his shop and went away. And after repeated calls, the petitioner did not respond to the informant, my lord. Thereafter, he lost the affair. So only allegation is 420 IPC. So, my lord, will also kindly see the affair. There is no the main ingredients, that is inducement. There no tu mate tonka dele mu tate suna debi. There is no inducement. So you voluntarily paid a cash of rupees some 1,15,000.
Paid back.
No, thereafter he lost the affair. Due to my some personal difficulty or family problem, I closed this shop.
Not you pay the money, you have taken the money.
But affair has been lodged against me.
Oh, it's all right. You pay the money and wash it.
Yes, my lord.
You should notice opposite party. You have not implicated opposite party.
I will implicate, my lord.
That's the whole difficulty with it.
My lord, I will implicate.
And the whole difficulty, you have taken money, you have to pay that money and quash it. Simple. And you don't implicate. He will come and
allegation also there. And he is a habitual cheater.
I know he might have taken money. In the name of jewelry shop, he might have taken money.
Yes.
Let us understand what is it. Implead it. Implead. Let counsel for the petitioner seeks permission to implead the opposite, implead the informant in the present case of opposite party number 2. Let him do so within 2 working days. Please the matter after. Yes.
Lordship, kindly case is posted.
You file an incomplete petition. I want to help you out. What way I will help you?
Lordship, I will file a petition.
No, nothing to.
No. One line, my lord.
No. Next item. This is unheard of. You file a petition incomplete. Don't impede right people. Yes.
Challenging the order of cognizance at page 32 under section 120B, 120B, 2, 50 and 34 of the IPC.
Yes.
The fact of the case is that, so far the present petitioner has concerned, they have filed a 1cc case in the year 2012,
and subsequently against the present opposite party number 2 under section 506 along with other offences, that is 1cc case number 190 by 2012, where cognizance has been taken against the opposite party. Yes. And thereafter he has filed a criminal revision application and the proceeding has been stayed by this honorable court. And during corona period that has been disposed of, directing the learned court, the matter was directed to be taken up for hearing by the learned court below. And without any notice to the present complainant, present petitioners who are the complainant before the learned court below, the case was ended in a acquittal. The order was that since the complainant were absent, the accused is acquittal. And thereafter, I have filed a criminal revision application where notice has been issued by this honorable court challenging the order of acquittal, that is criminal revision number 419 of against that acquittal order. Against that acquittal order. While the matter stood by in order to take a revenge, he has filed this defamation case in the year 2022 where cognizance has been taken. Only the allegation is
What happened?
he has defamation because he is acquitted. Because he is acquitted. That acquittal order you have already challenged, saying that that is criminal revision 419.
The person initially initiated 1cc case against the present complainant.
I understand it. Yes. 1cc case has been initiated by him. Somehow he did not appear, as a result of which they are acquitted. Thereafter, he has challenged that acquittal order. Yes. Acquittal order is pending.
Yes.
These people are saying since he has prosecuted maliciously, so defamation. And the complaint is filed. That's what this
1cc case which is pending.
Issue notice. 500, only 500. 500. Okay, issue notice returnable not also. So may I favor stay of further proceeding, ma'am? Oh, stay of further proceeding. 500, what will you do? Nothing.
26.
And you file the process?
Yes.
And
Tomorrow.
What was the initial complaint filed by you? That is, my lord.
They have
No, what are simply tell me what are the offences? That is, my lord.
They have lodged
Legal dispute. Mane bada bhangutale assaulted each other and 506.
In fact, the complainant has filed a civil suit against the accused, which was pending since 2011.
I know the understand. 341. Intercept.
And he has filed the civil suit against them and obtained status quo order. They initiated a false case against the company.
He must be, your client must be harassing them.
Yes.
No, filing criminal case, civil case. 82 years old lady. You are 82. Yes. At this age also you are interested.
And also the complainant is 72 years.
Get ready to pay some money. Forget about defamation. Pay the compensation in the sense the litigation expenses. At least you made them to suffer that complaint case. At least litigation expenses you must pay.
They made us.
I don't know. They are acquitted now.
They are
acquitted now. So therefore, at least litigation expenses you must pay. Get ready to pay some heavy cost. I will drop the proceeding.
Not heavy cost. It is pure.
Yes.
26.
26. There was a land dispute. The civil suit filed by the petitioner.
Let them come. Pass over.
27.
Pass over. 28.
58.
No, it should pass over.
Pass over.
For item 28.
29.
Yes, madam.
Pass over.
Pass over. We ask you for pass over.
30.
Pass over.
31.
Display board is functioning.
Yes, ma'am.
Petitioner challenge the order of cognizance by number.
31.
31, yes. The petitioner challenge the order of cognizance by order taken against him under section 376 IPC. My lord is a covered case. Also, your lordship has granted stay. The allegations against the petitioner, allegation in the information FIR, my lord. More name Mitarani Behera, boys 26 ବର୍ଷ ପିତା so then I'm going to the relevant person. ସେ ମୋତେ ବିବାହ କରିବାର ପ୍ରତିଶ୍ରୁତି ଦେଇଥିବାରୁ ମୋ ସହିତ.
Where is that?
That is my lord.
3390 of 2020.
CRLMC 3390.
Just take it up. 3390.
That is at the instance of other co-accused persons, my lord. And taking this into consideration, and when it's directly covered, my lord, why should I go there, my lord, once I have drawn your lordship's attention that this is covered by a Supreme Court decision, not by one Supreme Court decision, but many decisions, and your lordship has stayed, my lord. Why should I go and
I'll issue notice. Yes. Because see, the judgment is direct.
Direct, my lord.
Direct, this para just Nagaratna's judgment is direct, right of petitioner.
And the psychological impact on the lower court is, my lord. If the High Court didn't quash, why should we?
Yes, petitioner is accused in the FIR number so. After investigation, charge sheet has been filed in the present case on 22/8/2023. Subsequent thereto, on 22/8/2023, the Learned Trial Court has taken cognizance of offences punishable under section 376 2N, 294, 506 and 34 IPC. 34 IPC. The allegation against the petitioner are as under. Allegation is under. Mr. Naik, senior counsel appealing for the petitioner, has relied upon the recent judgment of the Honorable Supreme Court reported in Manupatra Print and so on. Para 12 of the judgment reads, Para 19 of the judgment says 19 correct. In view of the position of law, as has been enunciated by the Honorable Supreme Court in the aforementioned judgment, the submission made by Mr. Naik, Senior Counsel, deserves merit. Hence, issue notice to the opposite party, returnable so and so, the trial court proceeding, so and so will stay. Yes.
Interim stay, my lord. Your lordship,
I have stayed the trial court proceeding. Yes.
32.
No. And shall I take it? Co-accused?
Yes.
Co-accused?
Yes.
No, not co-accused.
Yes,
Saraswati Barik is not.
It's a mother and
No, arising out of the same proceeding or what?
Same.
Or tag with this. Yes. In any case, there is an interim order in that case. Interim order is not required. In any case, the interim order is there. Okay, I stated it, but in any case, there is an interim order. Tag with that. When is the date? Next date?
But I'll
tell you one thing. You should move. Meanwhile, you should move application under 227.
The foolproof case, I humbly request your lordship on the foolproof case.
279 will go. 276, 2N will go. The other things will remain.
Should also go. Your lordship will examine. Others should also. If your lordship finds a case which is covered by the Supreme Court decisions, my lord, are you not entitled to get the bar is not entitled to pay, my lord?
Yeah, tag with that. Okay. See.
32.
32, the NDPS Act. 522 green hemp plants have been seized from the accused person.
Quashing. Asking for quashing or what?
Belgium, I think.
Belgium.
Bail was granted, date was not mentioned. So the NBW is issued.
No, the NBW, then I'll say that let him go and appear.
That is, NBW was issued 5th April 2010.
Oh, let him come with passport. I'll just go. Just come.
33.
33.
I am honorable member paper adjournment.
Adjournment.
Yes.
A copy of the brief may be supplied to me in the meantime.
Give a copy.
I have instruction to.
But we'll go to February.
Yes, sir.
Please it in February. On request, adjourned. Copy of the petition may be.
Yes.
There you go.
34.
34 may please, Your Lordship.
Yes, sir.
Here, my lord, the limited prayer of the present petitioner is for expeditious trial and disposal of the, my lord, case. That is a case of the year 2008, and it was, my lord, that is a Kandhamal Danga case, Lakshmanananda Saraswati and the Hindu Christian Danga case. And in that case, my lord, different ST cases are, my lord, registered. And there are, my lord, FR named accused persons are, my lord, more than, my lord, 200, 300. So different ST cases are registered subsequently, and thereafter these petitioners, my lord, their case has been registered in the year 2022. First one ST case was, my lord, registered, and in that case, informant is not coming in spite of several summons, my lord.
Very good. You will be acquitted.
My lord.
You will be acquitted.
Acquitted, my lord, but trial, if trial will not completed, my lord, we are suffering. We are labor class people, and we are, my lord, worked at Kerala, and we have to reject.
Sometimes targeting these kind of cases is inviting conviction. Do you know that?
Any date, my lord?
Targeting these kind of cases is nothing but inviting conviction.
Conviction effort ସମସ୍ତେ ଆଜ୍ଞା hostile ମାନେ କେହି କହିନାହାନ୍ତି ଆମ ବିରୁଦ୍ଧରେ କେହି ଜାଣିପାରୁନ ଚିହ୍ନାହାନ୍ତି.
That means good. Trial is going on.
Trial is going on.
Let it go.
Witnesses are examined.
Let it go on to see. We don't know how many witnesses are there. Nothing is there.
Oh, informant and IO, I have the instruction that informant IO there.
Petitioner is accused.
3 months, your lordship.
Which is that petitioner is one of the
That
accused. How many petitioners are there?
2 petitioners.
Petitioners are the accused.
In ST case number.
ST case number 1 of 2022, arising out of Daringbadi PS case number 57 of 2008. How many accused persons are there?
And these 2 persons, a separate ST case. That is ST case number 34 of 2000.
The present case is going on. At this stage, the petitioner has approached this court for a direction to expedite the trial. Needless to say that the petitioner being accused, the petitioner being accused has statutory and constitutional right of free, fair and speedy trial. Therefore, the prayer made by the petitioner in the present petition is married. Hence, the petition is disposed of with a direction to the trial court to do and to see that the trial of the case is disposed of as expeditiously as possible. Yes, sir.
That is ST case number 34 of 2020.
34 of, yes. Yes.
35.
Yes, madam. Passable. Yes.
36.
36, my lord. Sir, I am challenging the order of cognizance here on the ground that the opposite party number 2 informant is lodging multiple affairs against the present petitioners, my lord. That one after another, and there are, my lord, almost 3 cases I have registered. Same set of facts. The informant is lodging affair by himself or by his wife, and offences are under section 341, 294, 506, and 34 IPC. These are, my lord, PT offences. Though, my lord, one affair that is by Annexure 1 that was registered on 21/3/2022 against the present petitioners by the OP number 2, that is Bhabagrai Pradhan. Thereafter, my lord, in that case, my lord, the police during investigation released the present petitioners, my lord, by invoking 41A and of the CRPC. And when they are not arrested, then, my lord, after 8 days, another affair has been lodged by the informant's wife, that alleging the same set of facts, my lord. ଗଛ କାଟିଦେଲେ ଗାଳି ଦେଲେ ମାରିଲେ ତାପରେ ପୁଣି ସେଥିରେ ମିଲର୍ଡ that in that case the subsequent case that was ମିଲର୍ଡ after investigation police found no evidence and ମିଲର୍ଡ discharge the
Then you are seeking quashing of the first FIR.
first FIR and thereafter
What is this investigation is over?
investigation over in the Millard, I have annexed the annexer.
Charge sheet is filed now?
Charge sheet filed, Millard. Charge sheet has been filed. And there is a judgment of Hon'Ble Millard Apex Court. Your Lordship may kindly. In para 12, there Millard, they have stated there. In para 12, it is held, yes, Lordship, if multiple first information report by the same person against the same accused are permitted to be registered in respect of the same set of fact and allegation, it will result in the accused getting.
But same person is not filed.
Her wife, his wife has been filed. And thereafter another FIR in the month of June by the same person. That is annexer 3.
Must be related to different.
Se khali got incident. Oh, say.
But here incident is same.
What's the contact lagi ki? Se tangara alga bane FIR.
I'll simply issue notice. Let us see if unnecessary. Issue notice. No entry model. I'll just because no case is made out as such. This judgment will not help you. In this judgment, what had happened, you know.
Issue notice to option number 2.
I am just issuing notice. Let him come.
Well, I am taking trial in different cases.
I can't say because see, incidents pertain to different dates.
Different dates.
Different dates. You might be creating problem every third day. What to do? I'll just call him after 2 weeks. I will just see if you can persuade and finish it up. Yes.
I will file requisite
by tomorrow. Yes, next.
By day after tomorrow.
My lord, 37.
My lord, 37. Yes. In pursuance to NDPS issued by Civil Judge Judicial Division Kujang in 1cc case number 3122, the present petitioner is in custody since 26/7/24 for non-deposit of 20% of compensation amount awarded by Learned Civil Judge Junior Division Kujang. My lord, again the petitioner approached before the Learned.
Yesterday I passed some more.
Another one is. This is another one.
Same accused.
Same.
How many checks you have issued?
Only two checks. 2 checks, my lord. 2 checks. Annexure 4, my lord.
Same order passed. Yes. 2 minutes. Allowed.
Case number 3792.
Yesterday I said that within
7 days.
Within 1 week you have to deposit,
yes,
and within 2 days you will be released.
Yes.
Only by moving application and all.
Yes.
Same order passed. Yes, allowed.
3792.
38.
Let's see. Same order group. Number.
On behalf of Mr. Biplab, your lordship.
Yes.
In this case, your lordship, the petitioner's account is freezed by the opposite party number 2 and 3, and prayed for defreezing it. Last occasion, you have ordered to take instruction.
Have you got any instructions?
Instruction. The matter pertains to OPI. No. I offer the instruction that it is not OPI matter. It is schedule conduct.
Yes, sir. Lordship, got it.
From the I have obtained instruction. No OPI act is there in that. Yes.
Yes.
About instruction.
Yes. What instruction you got?
Lordship, preliminary charge sheet has been filed. The investigation is still under process. Lordship, it has been submitted that one bank account of
who has freeze this account?
Yes.
UW.
As per the annexure 2,
yes,
by the at page 17.
Yes. What is the stage?
Stage is under investigation. It's not the charge sheet has not been submitted.
Yes. You just seek instruction whether this account, the account which has been freezed, is required for the purpose of investigation or not.
So that's what that amount has not been.
You don't have complete instruction, it seems.
So that specific line of instruction is.
That's what, see, he wants defreeze up for that account. If it is not required, you have to tell investigation is complete and it's not required or required, whatever. Whatever, you seek instruction, right?
Specific account.
Mr. Counsel for the state seeks 1 week time to get instructions regarding the prayer made in the present petition. Please the matter. Yes.
Pardon my lordship. I think it is written and about upon the continuation of freezing of the bank account number so and so of the petitioner to the tune of 2,50,000 involved amount is very much required, essential for the purpose of further investigation and interest.
When are you going to file charge sheet? You tell me next. Okay, start asking. Yes.
Your lordship, short date make it.
Yes, next.
39.
39. Password.
40. 40 May.
Yes.
Present in the case under section 20B2C of NDPS Act, that the present petitioner is the father of the accused. He has come to this court as he stand as a surety for his son and his son was released on bail. And this person, the father Banshidhar Sahu, stood as a surety, and thereafter his son, that is Jummesh Kumar Sahu, arrested in another case and in a 21C brown sugar case, and now he is in jail custody in Chaudhar jail. So thereafter, Lordship may kindly turn to Annexure 2, the order sheet of this of the learned court below.
Yes.
Then order dated 13/4/2023. We have intimated that the accused is in custody in another case, Jummesh Kumar Sahu is in jail custody in connection with GR case number so and so, and one PW namely so and so.
Where are you reading?
My prayer is
Where are you reading?
At page 50.
Page 15
Accused persons are absent. Accused was pointed out to also. Other accused persons also in jail custody also. Yes, what do you want?
Now, in page 17, Lordship may kindly turn to page 17, order dated 4/12/2023. A proceeding under section 446 has been initiated against me. I am the father. I am praying for passing of the same, because I could not produce the accused.
Yes, what do you say?
Lordship, at page 16, may kindly have that.
Yes.
Specifically in all those subsequent dates, Lordship, it has been that no instruction has been received.
Forget about that. Now he stood as a security for his son.
Yes.
Okay. And his son got involved in another case.
Yes.
He is in custody. Then he is in your custody. Why should you proceed against him under 446?
Right.
You can't do that. Right of petition is agreed by the order dated 4/12/2023, passed by the learned additional sessions judge Baliguda, whereby a proceeding under section 446 CRPC for realization of the bail amount has been initiated against the bail. The petitioner stood as a surety for his son in regard to the FIR number, in regard to which
FIR number 153 of 2020.
PS case number?
Baliguda
PS case number 153 of 2020 for alleged offence under section 20B Roman 2C of NDPS, read with by 25 and 29 of NDPS. NDPS. And consequently, the petitioner submits that his son got entangled in another case, being PS case.
That is a PS case number mentioned. GR case number 35 of 2022.
35 of 2022, and has been arrested in the said case. At present, he is in judicial custody and lodged in
Chaudhar jail.
Therefore, the proceeding initiated by the trial court by the impugnment order liable to be set aside because he cannot because the accused for whom he stood as a surety is already they're in judicial custody in connection to the another case. The submission made by the learned counsel for the petition at diverse merit. Accordingly, the impugn order dated 4/12/2023 is liable to be set aside. Regarding to the aforementioned, the impugn order dated 4/12/2023 passed by additional Sessions Judge Baliguda in city case number 42 of 2020 is set aside. Yes.
41.
And the trial court is directed to issue appropriate process for appearance of the accused in accordance with law. Yes. Yes.
41.
The Belgium matter, initially he was on released on bail, subsequently on 2012, 2021, he was
released bail on when you got the
bail on 26/3/2021, madam.
And NBW issued on?
And issued on 20/12/2021.
20?
20/12.
Okay. 500 years.
42.
May I please? The petitioner has filed the case for passing of the cognizance against himself only, Miller. The passing of the cognizance against him only, because he is serving as a peon in the court below. When he was not present in the place, Miller, his statement has been recorded page 17, may kindly see, by the police. But he has been arrived with the accused in this case, Miller. And the number of persons,
Ashish Kumar Mukhi.
Manner.
Okay.
Ashish Kumar Mukhi, in fact, he was not present there, but he has been told to reduce the evidence under section 164 statement. Thereafter, only he has been arrested as accused by the police.
What are the allegations? Let us see.
Allegation that
merely because your statement under 161 KRPC is taken doesn't mean that you will not be made accused.
No, the fact is that.
Let us come to the evidence. Come to the evidence.
আমার ভসাণী ভিতরে কালী ভসাণীরে ପିଲାମାନେ ଗଣ୍ଡଗୋଳ କଲେ ଯୋଉ ପିଲାମାନେ ଗଣ୍ଡଗୋଳ କଲେ ସ୍ପେସିଫିକ ଏଲିଗେସନ ଏଗେନଷ୍ଟ ୱାନ୍ ପର୍ସନ ସିଏ ତାକୁ ମାଡ଼ି ବସି ମାରିଲା ଆଉ କିଛି ଲୋକ ଠିଆ ହେଇଥିଲେ ଘୋ ଘୋ କଲେ ଇଏ ଲୋକ ଅଛି ବୋଲି କହିଦେଇକି ପୁଲିସ ତାଙ୍କୁ ଦିସ୍ ଇଜ ଦି ଫ୍ୟାକ୍ଟ ଆଉ କିଛି ନୁହେଁ ଯୋଉ ଲୋକଟି ପୁରା ମାଡ଼ ହେଲା ସେ ଲୋକ ଜଣକ ଏଫଆଇଆର ଆଇ ଏମ୍ ଷ୍ଟେଟିଂ ରିଡିଂ ଦି ଏଫଆଇଆର ପେଜ 12 plus 13 may kindly see.
What is your name? Your name is?
My name is Tinu, alias
Tinu.
Okay. Alias Ashish Kumar Mukhi. Dinesh Das, Pita Niranjan Das, Olisa Upasa, Chandin Chowk, Adivasi Hotte.
Your name is there in the FIR.
My name has been inserted in the FIR.
No, inserted. It's not there.
No,
see the FIR. Tinu means what? Not there. Somebody was inserted.
No.
In fact, clear name.
My name is in the FIR. But
charge sheet, just read it, sir. Charge sheet, informant statement. Informant statement.
Has not been provided.
Charge sheet. You can't file selective statement 161. The other people might have said.
His brother and they say they have stated.
Show me the entire charge sheet, sir. Otherwise,
certificate copy of the charge sheet.
You file for petition 6 to 1 week time to place on record the additional document to substantiate each case. Release the matter. Advance copy be supplied. Yes, next.
43.
In respect to the petition, the further process to be kindly.
You have not filed the complete petition. The substantive documents have not been filed. You file. Yes. You can't select 161 statement and file it and say that cause it. Your name is there in the FIR, very specifically. Investigation has taken place and thereafter charge sheet is filed. Many witnesses have taken your name.
Of the brother of the.
Whatever name, your name is specifically taken by the witnesses. Yes, after 2 weeks. Next.
43.
Please, my lords. Now, this is a bail job matter, my lords.
Yes.
The petitioner was granted bail by this honorable court, which is in Annexure 1, dated 24/2022.
24? 24?
24, 2022.
Otherwise, NBW 22/9/2023 is 500. Yes.
44.
My lords, item number 53 is also in the 54 is also in the same light, my lords. This is the petitioner's wife.
Give the date. Give the date.
My lords?
Give the dates.
Dates, my lords. I'm just giving. 54.
54.
Yes, my lords.
54 also. Give when she was on bail.
The other person was on bail, my lords.
39/2022.
39.
2022.
2022 and
Yes,
NBW.
NBW 22/9/2023.
Okay. 50 also. Yes.
Grateful, my lords.
44.
May I please, well, the petitioner filed a petition for recall of three PWs, PWs 1, 2, and 4. And the PWs, some vital questions were not put to the relevant witnesses.
Yes.
PW 2 is the victim, PW 1 and 4 are parents of the victim. I have annexed the annexure 1, the recall petition. But the learned special that has rejected my petition. That means
PW1 is the victim.
Mother. PW 2 is the victim, mother.
1 is the mother.
Mother.
And 4 is the father.
Father.
Okay.
Questions I have also in the petition, annexure 1, I have already put the questions.
These are suggestions or questions?
Yes, sir.
These are suggestions. Just see the questions.
I'll file separate application that will consider.
These are all statistical suggestions being provided.
He knows where the problem is.
That's why I consider to file fresh application that will consider.
I don't know. Petition is agreed by the order dated 11/9/2024. Passed by the additional session judge, fast track under POCSO Act in GR case number 21 of 2023, whereby his application under section 311 CRPC for recalling witness PW1, 2 and 4 has been rejected. The petitioner has placed on record the application under section 311 CRPC moved by him, wherein the proposed questions are enumerated. When the questions, when the relevancy of the questions proposed to be put to the said witnesses are inquired. So the counsel for the petitioner, he fairly concedes that the questions enumerated in the applications are not happily worded. Therefore, he seeks liberty from this court to move a fresh application before the trial court in that regard, by enumerating appropriate questions to be put to the witnesses. I'm not inclined to interfere in this petition. However, dismissal of this petition shall not preclude the petitioner to move a fresh application under section 311 CRPC before the court below. If such application is moved, the trial court shall deal with the same in accordance with law. In accordance with law on its own merit. Yes.
I don't know, dismiss me, dispose of.
Yes. Thank you. Yes.
So blessed.
Is corrected. Okay. Yes.
45.
May I please? Yes, sir.
I am challenging the order dated 23rd 9 2022, where my 457.
Avoid writing that Republic of India and all. First objection of Mr. Naik is that. Republic. Yes.
Let him amend, your lordship, the cost.
Amend it, because there is now a Supreme Court order.
My lord.
Don't write Republic. You amend it, I'll take it up.
My lord.
Tomorrow?
Tomorrow.
You have also not annexed the passport.
Day after tomorrow.
Let him annex the copy of the passport also, your lordship.
I will annex it first.
Day after tomorrow.
Yeah.
My lord.
Yes.
46.
It on 46 is a concurring matter. In this case, no.
Mr. Naik, you give one more copy of that Supreme Court order.
Sir.
Research the why is numbering all this?
It is being repeated, your lordship.
That's good. I'm giving it to the registrar, please see. Don't number it if this kind of cost type is there.
Not this.
So that at least you curtail the time. Unnecessary.
Not this is a concurring matter. In this case, the opener of could not come. He is in Bangalore. What is the matter taken on the third or fourth? No, has to come. Though he asked to come today, he could not come.
What are the offences?
350.
He doesn't want to come, then let it come after 2 weeks.
No, third or fourth has happened.
He will not, the accused will not decide which date the court will take. I'm just entertaining you because of you are there in between. Who is accused to dictate the date? Who is accused? First of all, I'm lenient enough to give indulgence to you for quashing on the ground of compromise. There is a 354. And now the accused will decide a date and dictate to the court that I'll come on such and such date, please wait. What is this? This is crossing all limits. Don't do that. Please. Please it up. Why should the court will waste time waiting for an accused?
Because he has assured to come today.
And then he has to, feel the pinch of it. I'll impose heavy cost next time. I'll cost it, but I'll impose cost to be paid to the victim. Tell your client. At least 50,000 rupees cost to the accused to be paid to the girl. You have outraged the modesty of someone. Still indulgence is given by the court. Now you are fixing a date and saying that I'll come on third, take it. What kind of prayer is this? Get ready to pay heavy cost to the girl. Next. Put it next week with an indication that the heavy cost will be imposed. Yes.
47. Item 47 kindly pass.
Yes. Pass over.
48.
Madam, remind me on that day.
Yes,
when the
ma'am.
matter comes.
Yes, ma'am.
Don't write.
Yes, please, your lordship. My lord, this case against the petitioner, who is the president of the Capital Cooperative Society, is totally an abuse of the process of court. Initially, an allegation was made. I will take the lordships to the charge sheet, which will show that two sections, 420 and 468, are not made out. But the background of the case is, my lords, initially after he won the elections, my lords, election disputes were filed against him, alleging that he has 4 children. Now, these election disputes were dismissed with the finding that he has 2 children. Now, what they do, one Deepak something, my lords, he was not even a contestant. Deepak Parida.
You contested.
Yes, my lords.
You are equally challenged by the other party.
Yes, my lords. Our election was, when I won the election, our election was contested by the.
Because you have more than
2 children. We have 4 children.
Yes.
Now, my lords, so what happens, my lords? Both the election petitions were dismissed. Now, thereafter, one Deepak Parida is set up and he files a criminal case against the petitioner, alleging that he has cheated and he has forged document.
What document forged? Which are the documents?
Initially, if your lordship sees Annexure 1,
page 14.
May I be permitted to do my learned senior? I am according for the, I have instructions to appear for the informant, your lordship. In fact, my learned senior were copy maybe some and address your lordship because.
Let me understand whether how it is relatable. This case is relatable to the election petition.
Exactly.
Relate that.
My lord, I'm coming to it. Now your lordship says, I'm first taking your lordships to the FIR itself. Initially, it was lodged under 420.
Yes.
With the allegation that I have 4 children and I've cheated. Whom have I cheated? And then they say that I filed a false affidavit.
That is a part of for the allegation there in the election petition.
There in the election petition.
How do you
And that apart, my lords. Your lordships asked us to wait till the charge sheet to find out what exactly are the allegations against him. Now, at page 24, 13th line from down, your lordship gets it? Submitted. Requisition. Your lordship
The
gets
same declaration and
before chief, no. With a chief executive of Cooperative Society Bhubaneswar to provide declaration affidavit undertaking form submitted by Vishwaranjan Mahanti during filing of nomination paper in the post of president.
See, the problem is the declaration and affidavit which he has given.
No, but
it has been tested in the right proceeding. And it is not relied upon. On that, you can't make that as a basis to file an FIR.
Let the copy be served.
No, my lords. Another point is, I have not given, he has clearly stated, the chief executive officer of the Cooperative Society says, replies that there is no declaration, affidavit or undertaking given by Shri Vishwajit Mahanti in respect to the 68.
And issue notice, so and so accept notice.
I'll give a copy.
2 weeks time to file reply. Lease the matter and so and so in the interim the proceeding before so and so date. Absolutely misuse. You satisfy? I am satisfied now that prima facie same election petition. He suffered the election petition and only he has 3 children, 4 children. I am not interested in that. The document which is sought to be fabricated and manufactured, whatever, has undergone a judicial determination.
No,
and you file a FIR on that.
The criminal side part of it is, yes, what I am given to understand.
The finding in the civil proceeding is binding on criminal court.
What I am given to understand, your lordship, is that 2 children has to be there, your lordship, for eligibility criteria.
That has been tested in the election petition. He owned that.
And once he has,
you lost it.
Once he has said that I have less than 2 children or 2 children, and he has 4, that is prima facie it is evident.
Who are you?
That I am satisfied on that.
Who are you? Tell me. You are a voter.
I am a voter.
How do the candidate who lost the election, he fought it and lost it. And now anyway, I'll just examine it. No problem. You file reply. Examine.
Copy to my friend.
Stay. Meanwhile,
stay of further proceedings.
That your lordship, I will file an objection to that.
Let me. I issue pass the stay order. It will go on for 5 years, and the tenure will be over. You will be happy. He will be happy.
Stay up for the proceedings.
Yes. Stay in after.
Oblige.
Yes. Yes. Yes, sir.
We have filed a petition for discharge of the petition, Miller. The vigilance case, Miller.
Vigilance. Yes, sir.
It is that case, lordship, last time heard, lords. To refresh your lordship, may remember, lords, the petitioner in a bid to be recruited in the post of sepoy in that police personnel, lords. He was awarded with marks under the heading of sports category, but he didn't have any kind of sports. But apart from this, but I've got the instructions of charge sheet or copy also. What I suggest, lords, Lord, challenge, if lords, you can see the page 18 of the petition, lords.
18?
Page 18 of the petition.
Yes.
Lord, that's the impugned order stats, lords. In this case, lords, in total, 32 accused persons are there. But in the meantime, I have got collected the number of another revision number is also there. And I will take the help of your lordship, staffs, my lord. The FIR outdated FIR number.
All of them applied for joining.
They are single revisions have been filed. What I suggest, my lord, if I can collect 4 or 5 revisions, my lord, can you dispose in one?
Yes,
sure.
You do that.
I'll
give
take
the
that
number.
And I will give that PS case number.
But they got the job.
Yes, they joined.
But after this case, they might have been removed.
No, they're
Continue.
continuing their since from the date of appointment.
What is your answer to that? You have a sports quota?
No.
Then
they have awarded the mark in what basis? They have awarded the mark in what basis? We don't know. We have no sports certificate.
In fact, in this case, my lord, that is the IPS officer.
No, I'm not worried about the criminal case. How will you save their job?
No, that I'll come back.
Because in any case, they are working.
No, I agree, Lord. It's a matter of bread and butter, Lord. So I'll come back to Lordship. What I suggest, today, I'll take the help of the staffs, Lords. And from that PS case number, I'll find out the number of revision cases. Challenge this particular PS case of 57 2013. I'll get the revision numbers.
Recruitment in which year?
In 2018.
And in this case, Lordship already passed the order granting them the liberty to move the adjournment petition, Lords. So that's
2008 they are working. Today is very harsh.
I agree, but this is a case, total 32 accused persons. So at least if all these revisions, within 1 week, can be disposed.
Mr. Das, letter counsel for the Vigilance, submits that the co-accused persons have also challenged the impugn order by filing separate. He would be supplying the details of those petition, release the matter along with the petition which he is going to give interim order to continue. Yes.
And let's I will take the help of the.
Yes, definitely. It's always welcome. Yes.
Item 50.
Yes. Yes, madam.
27/8/2018, with Hon'Ble, and NDPS was issued on 17/5/2022.
Released on bail on
22.
4/9/2021.
Okay.
And NBW was issued on 11/8/2020.
500 each. 500 each.
50, right?
Let's see the dates. Babuli said. Correct? Your dates are correct? I think, no, my lord.
What I have submitted, that is correct, my lord.
What is that? 49?
4/9/2021.
21, yes. That is NBW.
That he was released on bail.
Okay.
And NBW was issued on 11/8/2023.
Take this date. Okay. 500 each, yes. Next.
51.
Yes, yes, madam.
May I please yours? What is Belgium matter? The bail was granted on
22/8/2016. And
22nd or 2nd?
22nd.
22/8/2016 bail. NBW
18/7/2024.
24. 500.
52.
Same.
52, same.
Yes.
52, same. Dates are same? Yes. All the accused, huh? All the 500.
53.
May I please your lordship?
Yes.
The bail was, this is a Belgium matter. The bail was granted on 1/9/2023 and the NBW has been issued on dated 8/12/2023.
How many of you are there? 500, yes.
Obliged.
5.
This is a Belgium matter, my lord. That's bail was granted 26/11/2013. NBW issue 18/7/2024.
500.
24.
24.
No, my lordship, bail was granted on 26/11/2023, and he is saying that 2013.
13 hours.
The
Bank.
Yes, my lordship. 2013.
Obliged, my lord.
56.
May I please your lordship? May I please, your lordship?
Yes, madam.
My lord, NBW issued on the 1/12/2021, arrested, released on bail, my lord, 4/10/2020, 14, my lord.
Madam.
4/10/2014, he was released on bail and NBW was issued on 1/12/2021.
Okay, 500 each.
Oblige, your lordship.
May I please, your lordship? Your lordship, kindly see the order, your lordship earlier passed, my lord, page number 13, my lord.
13?
13, my lord.
Okay.
Paragraph 4 and 5 of your lordship, sir.
Yes.
This is a case based on only circumstantial evidence. The last scene is the circumstances cited against the petitioner, apart from the fact that there was disclosure leading to recovery under section 27 of the Evidence Act. The prosecution had examined 3 witnesses under section 80. They are named Urop, Soren, Natho.
They have been examined?
Yes, my lord. Now they have examined and declared hostile, my lord. They are page number 20, 21 and 23.
That all not right. Some other witnesses are already.
But see, that was the culture. Right. Petitioner had earlier approached this court by filing the BLAPL number 14140 of 2023. This court, while disposing of the bail application, by the order dated 2/8/2024, has passed the following order. Para 3, para 4, 5, and 6. 4, 5, 6, 7. 4, 5, 6, 7. Okay. Pursuant to the aforementioned, the trial proceeding in this matter, and where are the statements?
20, page 20.
Page 20.
My lord.
The aforementioned aforementioned witnesses
21 and 23
as enumerated in the as named in the earlier order of this court were examined as PW 1,
4, my lord, 4,
PW 4,
5 and 6.
4, 5, and 6. All the 3 witnesses have turned hostile and resigned from their earlier statement. Therefore, the circumstances cited against the petitioner to establish the complicity by the prosecution has no supporting evidence. In that view of the matter, petitioner is entitled to bail at this stage. Petitioners. Yes.
52
And condition same, you would appear in.
Yes, my lord, each day.
Without bail and all. Yes.
Not threatened, my lord.
Certainly witness.
Yes, no, it's already.
Yes.
Next
week.
Next week, your lordship had initially rejected the application, saying that the victim's parents had to be examined. In the meanwhile, the father was examined. I have given his copy, and the mother has also been examined.
Have they supported?
And filed that copy.
Have they supported prosecution?
There is a lot of contradiction.
Let us see. You give the copy. If the apparent contradictions are there, at least he is entitled to bail. Baki to conviction hoga hi dekhte.
I give the copy.
Yes.
59.
After 1 week. After 1 week. Yes.
Next week, he'll date.
He'll give a date. He'll send your junior so that he'll get it. Good is Yes.
59.
Please, your lordship. Here, my lord, the case on discussion 302/34 IPC was registered against some 5 persons, my lord.
Yes.
The petitioner not named the affair. He is in custody since 2011-2023, my lord.
2011.
My lord, 2011-2023. Charge sheet has been filed on 16/3/2024, my lord.
Yes. 63/2024. Yes.
My lord, so far the allegation, the father lodged affair, allegation that his son was missing, my lord. Thereafter, the dead body was found in a canal, my lord.
Yes.
The father lodged against 5 persons named in the affair, my lord. So far, the present petition is not named that. Then thereafter, in course of investigation on suspicion, my lord, it came to light that the deceased has relation with the wife of the petitioner, my lord. Then, my lord, the allegation that there was a quarrel between the husband and wife with regard to illegal relation between the deceased and the wife, my lord.
Well, you have not filed anything where from Margaret except the order, there is nothing.
This is the FIR, your lordship.
But problem is the
Out
all
of the
paperless.
it is ମୋ ପାଖରେ ନାହିଁ ଖାଲି ଏଥିଲା ଯାତ୍ରା
File something because these are paperless court. Where from I'll get all this?
only by confession. 27
That's right, but except the rejection order, you have not filed. At least you file or show me something. Where from I'll get it all this? Up to 1 week. Yes. If you want to substantiate your case, please file it because these are paperless court. Whatever he says, I can't take it on record. Yes.
Let's not keep it date.
Yes, yes.
60. Custody since 9/7/23. It was before the lordship 9/7/23.
60.
My lord, out of 38 witnesses, only 10 have been examined.
37 witnesses. 38 witnesses.
And out of the witnesses examined, most of them are turned hostile.
26 today.
And your lordship's order. Your lordship was pleased to pass an order annexed 3, page 30. And he has been released twice on interim bail and never misused the.
What is the recovery?
Recovery is 420 kg from 4 motorcycles.
Show me that Ravi Prakash. Ravi Prakash.
କଣ ଏଇଟା କଣ ସେ ବସିକି ବାହାର କଲା
ଆଚ୍ଛା
ଦୁଇ ବର୍ଷ ରହିଲା ବୋଲି ତମେ କରିବନି ତମେ ତୋର କଣ କରିବା କଥା କହିବ
Yes.
26.
Where does it say 3 years? Custody?
3 years. 2 years old.
Huh?
2 years old.
Where is that?
Drug was the petitioner was one of the occupants of the drug. Arrested on the first spot, he has been custody for 3.5 years. Second paragraph last.
Second paragraph.
There are no criminal antecedents.
And in this case
247 kg. Yes. And what about this? The other one?
here also I don't have any criminal antecedent.
Dheeraj Shukla. You show me the evidences which has been eight witnesses have been examined according to you.
26, your lordship.
26.
26. Annexed 2 series, I have given the paper. Has, my lord, nothing was seized in my presence. Para 2. I was not examined by police. I put my signature.
That I specifically asked you last time the question. The exhibit, these are the seizure witness. The exhibits which are now mentions this witness, these exhibits are recovery or not, you show me.
My lord, your lordship has directed the state council to produce the details.
You have to tell me.
Yes.
What she is saying is the seizure witnesses have turned hostile. They say that in our presence these are not seized. Whether the contraband was seized and these exhibits are, any of the exhibits are the contrabands. If the seizure of the contrabands is doubted and the seizure witness is not supported, they are entitled to bail, as simple as that. That's what last time I asked the question.
And in the
Huh? The problem is, then you will change the count and then you will do. Next week, next week. I'll record your statement. I'll record all these things. I'll not leave it for that. Petitioner is in custody since 9/7/2023. Out of 38 witnesses,
Yes.
10 witnesses have been examined. The witnesses, those who have been examined, have turned hostile, not supported the prosecution case. These witnesses are the seizure witnesses. They have categorically stated that the seizure has not taken place in front of them. From the on the query from the court whether the seizure are related to the contraband or not, Mr. Jana seeks 1 week time to get instruction as to whether the witnesses were the seizure witnesses to the contraband article or not.
My lord, they will, your lordship may direct.
I am directing them.
And another thing, your lordship may kindly see, all the signature body of the plain bill.
I know that therefore let us see. Mrs. Jana, counsel for the petitioner, has relied upon the judgment of Ravi Prakash and Dheeraj Shukla, and submits that the petitioner is has already remained in custody for more than 1.5 years.
1.5 years.
More than 1.5 years. Therefore, the case of the petitioner is directly covered by the ratio laid down by the Honorable Supreme Court in Dheeraj Shukla Chopra and Ravi Prakash Chopra. Okay, please the matter for you.
My lord, your lordship may keep it to next week.
Free copy.
More of problem.
Give one more copy here.
My lord.
Free copy of the order bill.
Free copy of order I'll give a copy. Do you have a copy? Petition copy.
Copy.
Yes. Free copy. It all depends upon how. See, there are a lot of exhibits, so you have to locate them.
After this, I have some personal problems.
On 5th, let me on 5th. Let us see. You try.
Okay.
You try.
Huh? 64
Yes.
64
and 60.
the basis of the confessional statement.
64.
More
60? Well, I'll take it up. 61. 61. Co-accuse. There's a co-accuse. Then I'll take it up on 5th. I'll take it up 5th.
Permitted to notice the application, my lord.
Yes.
61 item.
Yes.
Permitted to notice.
Not place. Okay.
62.
May I please, your lord? Charge sheet submitted 498 304B 306 406 by 34 of the IPC for read with 4 DPI.
Custody
2823. 2823.
So many.
I have already filed charge sheet with statement, my lord. Your lordship can use the statement of one.
Where is that, sir? Where is that charge sheet?
Chandan Das, my lord.
Where is the charge sheet?
I have already filed.
Chandan Das.
Chandan Das statement. No Chandan Das as is shown so
Who is this Chandan Das?
He is one of the witness, my lord.
Yes.
He is
already.
ଆମ ଗ୍ରାମ ବନ୍ଧୁର ମୋ ସହିତ ବଳରାମ ସ୍ୱାଇଁ ମିଶି ନୂଆ ସାହି ଦେଇ ଘରକୁ ଫେରୁଥିବା ସମୟରେ ତୋଫାନ ପ୍ରଧାନ ଘର ପାଖରେ ପହଞ୍ଚି ପାଟି ଶୁଣିବାକୁ ପାଇଲୁ ଓ ଆମେ ତୋଫାନ ଘର ଭିତରକୁ ଦୌଡ଼ି
Regard being led to the period of custody and the nature of litigation and the fact that charge sheet has already been filed, I am inclined to enlarge the petition on bail according to with all conditions that. How would we talk about
69.
60?
Both parties present today. Matter compromised. 69.
One minute. What are the offenses?
Hence, my lord, section 370. Plus 30 for IBC. And 3 of the SCS.
Charge sheet has been filed. Charge sheet.
Charge sheet has been filed also.
What are the offenses? Let us see.
That's my lord. Child Labor Act.
Child Labor Act.
You want SC/ST Act.
Yes. Who is appearing?
Yes, sir.
Any legal impediment?
69. 69.
69.
69. Item 16.
69. 16.
Lordship, what happened? The notice was duly issued to the OP2. We are applying for the informant. OP2.
You don't have any problem.
No, I don't have it. I would like to file the Lordship, Lordship. My now may be accepted.
Yes.
There is 3 SCST and other alleged offences, Lordship. There is 3 SCST concern is Lordship, is not compoundable. Lordship is
Not compoundable, therefore they are
Yes,
here.
Lordship. Lordship is considered Lordship, though opposite party have no objection.
Is there any legal impediment? You have to only tell that if legal impediment is there, I'll not, I'll hear you. If there is no legal impediment, I'll quash it.
Lordship, for the interest of the justice, was the opposite party already entered a compromise and have no objection. Lordship, compromise.
No legal impediment. Affidavit.
Joint affidavit.
Joint affidavit. Petitioners are accused.
Parties are present, Lordship. Parties are present in person.
I'll just verify. Petitioners are accused in FIR number 22. Petitioners and notice was issued to the opposite party number 2 by order dated. By order dated. Order dated 6/1/2022. Persons there to so entered applicants. The petitioners and opposite party number 2 are present in the court today, being represented by their respective counsel and identified. After investigation, charge sheet has already been filed in the present case, and by the impugn order, the charge sheet has been filed. Where is the date of charge sheet? And
19/11/2022.
19/11/2022. By the order dated 23/12/2021, the trial court has taken cognizance for offences punishable under section 374. 370. It attracts life imprisonment. 370.
Imprisonment for a term sexual not less than 10 years, Your Lordship. 10 years.
10 years, no?
19.
Yes.
No, no, state of mind.
The STSC
370.
My Lordship, 10 years.
STSC like
10 years. Capital 4. 370 bracket 4 /34 IPC. Section 14 for Child Labor Provision Act, section 3(1) bracket H, bracket 3(2) V and VA of SC/ST POA Act. Before the trial commenced, the parties entered into a settlement, and the petitioner has filed a petition seeking quashing of the impugn order of taking cognizance and consequential proceeding arising therefrom. The parties have filed a joint affidavit before the joint affidavit dated agitated video before this court in India stating as under 3/2/11. 3/2/11. Mr. Mantil and the counsel for the state submits that since the parties have settled the dispute and after notice issued to the opposite party number 2, entered appearance and joined with the petitioner on making a prayer for quashing up for the criminal prosecution. Therefore, there is no legal impediment in quashing the FIR. Moreover, he submits that even if subjecting the petitioner to trial would be a futile exercise in view of the settlement between the parties and the opposite party number 2 in view of the affidavit filed by the opposite party number 2. Hence, the case of the petitioners are directly covered by the judgment of the Honorable Supreme Court in Gansing and so on, so on, so. Regarding head to the aforementioned, I'm inclined to allow the petition accordingly. Cognizance order so and so is last 1 minute. Where are the petitioners? Two petitioners, na? Three petitioners. Subject to where is the child?
That is your
Not taking disrespect to him. So therefore I'm imposed to.
Pardon to mention my a modification in the weekly list 122. Yesterday I have mentioned. My lord,
Modification of what?
my lord, modification of lordship order. Only my lords have released the order passed for release the petitioner. But in the those there is one antecedent in the criminal side.
I'll hear it. That I'll hear it.
I pray my lord taken. My lord today.
I'll take it up. Yes. 145?
122.
122.
Yes, legal loss.
Before that, some failed application status list. I will take them apply to reach 117. Today,
I'll take it up. Let me run through the list first. Let me run through the list. Okay. Huh? 3 bail matters. I'll take it up. I'll take it up. Yes. Which condition you want modification?
My lord, only my lord, the so far is condition number 5, your lordship, my lordship directed religion bail, my lord. Only one condition that the subject to verification of the criminal antecedent, lordship. My lord, in the rejection order, my lord, there is one criminal antecedent similar to my lord. Though my lord, petition language in jail custody on 7 February, my lord.
7th February.
My lord.
And what about the case where you have
9-2, my lord, 9-2-2024, my lord, he is in the custody.
9-2-2024.
2024.
Okay. And what is the similar case you were talking
My
about?
lord, lordship, I have glanced in page 11, lordship in the rejection order, my lord.
Yes.
My lord,
That I have seen.
my lord, only Govindpur PS case number 108, dated 1/6/2023. 108.
8 of 23.
23, lordship.
That is the similar case.
My lord. And
Are you on bail on that?
my lord, and in that case, my lord, the petition as well.
What do you say?
My lordship, it is, if it is more than commercial quantity, so section 34 will be.
Is the below, my lord, is not more than commercial quantity, my lord.
In the
76
other
grams.
case. The other case.
The
other case in which you are implicated. In that case, what is the recovery?
My lord, that ordership, my lord, in lordship of glance, please.
Tell me the recovery.
My lord, is also my lord, though that below commercial one, my lord, the bail is granted by the.
Where is that? Where is that?
My lord, that is.
Where is that?
My lord, that has been mentioned, my lord.
76 gram of heroin, my lordship.
No, lordship.
Not in that case, the corrected case.
My lord, only Passover lordship,
It will come after. I have given you preference.
Lordship, my lord, so far is not. Lordship, I am not, lordship, that one.
Next week. Yes, next.
My lord.
Pass over. Pass over.
Item 5.
Yes.
Here I have filed this application. Actually, the order of rejection, trial court has rejected my application and thereby dispensing the examination of both PW two the doctor PW 11 and 12, who are the doctor and the medical officer, madam. The concerned IO, madam.
Show me their evidence.
Madam.
Show me their
Evidence, madam. So they have not at all cross-examined. Not at
Where
all.
is that? Show me.
Madam, message of the page this. It starts with page 9.
9, huh?
Madam,
When 2000,
it was
May 2024.
Madam,
I'll give opportunity, one opportunity.
the ground I have taken.
Huh? In one day. One opportunity, singular opportunity. I don't.
Successive, two successive days. IO and doctor. My friend also know it's not possible to cross-examine
the things within a day.
But one day IO, one day
Madam.
the doctor.
Yes, madam.
Because what you are involved in this case.
376 case, madam.
376. Okay, right. Petitioner is agreed by the order dated. There are two orders you have.
No, but I am challenging.
1-5.
Well, the things even the concerned advocate was contesting for the post of MLA. He prayed at least for 30 days because after the date of this MLA election will be over. But the court has caught it and given only 6-7 days. Again, 6-7 days, that's why it was not.
Ultimately, you are agreed by the order dated 9-5.
No. I am agreed by the order dated 9-5-2020.
That's what I'm saying. Petition is agreed by the order dated 9-5-2024 passed by Learned Special Judge Poksho Barampur in GR case number 117 of 2020, whereby his application to recall PW 11 and 12 has been turned down. PW 11 is the IO, doctor. PW 11 is the doctor who has examined the prosecutrix, isn't it?
Yes, ma'am.
And PW 12 is the IO of the case. Perusal of the proceeding reveals that these two witnesses have not at all cross-examined by the petitioner. Petitioner is facing trial in a serious offense. He has indefeasible right to defend himself in the case. Hence, he has a right to cross-examine the vital witnesses, namely PW 11 and 12. Regarding head to the aforementioned, I'm inclined to allow the application. The trial court is directed to summon PW 11 and 12 by fixing 2 consecutive dates for affording and afford opportunity to the petitioner to cross-examine these two witnesses. It is made clear that the petitioner shall not seek adjournment and shall conclude the cross-examination within the time frame fixed by the trial court. With this observation, the petition is allowed and the application under section 311 moved by the petitioner. You have moved the application?
Yes.
311 is accordingly allowed.
No further.
It is made clear that if the petitioner shall not conclude the cross-examination within the 2 consecutive dates to be fixed by the trial court, no further opportunity shall be granted to you. Yes.
15.
Yes.
My lord, petitioner challenging the order of Cognizance dated 30/11/2023.
Yes.
Offense under section 468, 471 and 420 IPC.
Yes.
Petitioner is a teacher.
Yes.
Before that, my lord,
the BO is the informant. His lost the affair against present petitioner. Present working as a teacher, your lordship. By practicing fraud in his matrical certificate, is engaged in that service, your lordship.
He got the job by
by manipulating fraud.
Yes.
The prosecution certificate, your lordship. Therefore, affair has been lost and Cognizance taken.
Who is the informant?
Informant is the BO of the BO Birmarajpur, your lordship. Proposition officer, your lordship. Under whom is the appending authority, your lordship. BO is the appending.
Yes. Yes.
Let it come the LCR. Call for LCR, my lord, so that
you make out a case.
Your case
You're seeking quashing of the entire proceeding, it seems.
It's also
Cognizance order. Okay. What is wrong in Cognizance order? You tell me.
Sir, Cognizance has
ଟିକେ କହିଦେଇ ସେ ମାଇଣ୍ଡ ଫ୍ରେଣ୍ଡ କହିବେ ସେ ଆକ୍ଚୁଆଲି ପ୍ଲସ୍ 2 ରେ 378 ରଖିଥିଲେ ସେଟା ବାଇ ପ୍ରାକ୍ଟିସିଂ ଫ୍ରଡ୍ ହେଜ ଇନକ୍ରିଜ 4 9 It later on in the very inquiry, it has come to light and thereafter a fair draw.
Yes. What is wrong?
Prior to that, one CRLC has been filed and that has been withdrawn with liberty to challenge the order of Cognizance. Subsequently, stay NBW, which has been subsequently stayed by the
law and court below. Then by order dated 30/11/2023, cognizance has been taken and subsequently process has been issued under section 82 and 83. Since 29/1/2022, by taking cognizance 29/1/2022.
Yes.
Subsequently, petitioner prior to was this cognizance.
You make out a case why cognizance order is wrong. You are going here and it there. What is wrong in the cognizance order?
Conducting.
Petition of the urban thereafter enrollment issue during.
Where is the NDPS order shown?
That is page 35.
35.
22/3/2024 enrolled 82 notice 82 to 86 notice is issued. That was subsequently.
I'll set aside this order and go.
Already arrested and go.
Petition is seeking quashing of for the.
That was already. Yes.
Quashing of for the order dated 3 passed by passed by which court?
Yes, Lordship. That is.
Cognizance order passed by.
That is Burma Courier.
Passed by JMFC, yeah? JMFC. SDGM Suvarnapur. Suvarnapur in GR case number 383 of 2021, whereby cognizance of offences punishable under section 468, only 471, only 420 IPC has been taken against the petitioner. But it is subsequent thereto by the order dated 22/3/2000. NBW, when NBW was issued?
Your Lordship, 22/3/2024, Your Lordship. That find place, Your Lordship, page 35. That is the yes. So initially, what happened? Sorry, Your Lordship. That is, Your Lordship, page 28, Your Lordship. 28, Your Lordship. That is on 3/6/22, Your Lordship. Hence, prayer made by the IO, declaringly enrolled issued against the petitioner, Your Lordship.
Order dated
29/1/2022, Your Lordship. Page 28.
28.
8. What is number page? First, second paragraph, Your Lordship. First.
Instagram.
28. Yes. What is the? On 29/1/2022, NBW against the petitioner had been issued as he did not appear before the court. The execution, the NBW could not be executed after this best effort by the could not be executed for various reasons, leading to the order dated 22/3/2024, whereby the proceeding under section 82/83 CRPC has been issued against the petitioner. The Legal Counsel for the petitioner submits that the NBW issued against the petitioner and subsequent proceeding initiated against him under section 82/83 may be quashed, for the reasons stated in the application. I'm inclined to allow the prayer made by the petitioner insofar as the cancellation of NBW is concerned, subject to the condition that the petitioner shall appear before the court on or before the 20th of December 2024 and resort to the remedy available to him.
May I clarify? By virtue of this NBW petition already been arrested and there is a bail. So for my instructions concerned.
82/83 proceeding.
Yes, that was issued, but subsequently, in the meantime,
he says that NBW, thereafter there is nothing on record. He knows nothing. What to do? Have you been arrested?
Arrested
and released on bail. So why are you telling me NBW then? There is nothing in this matter. Dismiss. No merit in the case. So cut off. Don't prepare nothing. Yes. Please, miss. Yes. Next.
16.
Wait, please, Your Lordship. I'm doing adjournment on behalf of Mr. Mahapatra.
What is this case?
My Lord, what I'm remembering, my Lord, FIR registered, charge sheet filed showing the mistake of fact. Thereafter, the complainant filed protest petition, and after inquiry under 202, subsection 2, the learned court below take cognizance of 302, 201, 34. That so we hear the challenge of all these
Cognizance and 302.
302, 201, and 30.
In the protest petition.
My Lord. The mistake.
Yes, Lordship, what happened, the two minor children by the present person is the tuition teacher of the Lordship. By the call for a picnic, and thereafter the present petitioner.
Not on facts. I'm not saying in facts. Investigation is done by police. Final report, and thereafter protest petition is filed. 302 Cognizance.
Yes, Lordship. First time, Lordship, I brought with.
There is a recent order, Santosh Garudia. I will
issue notice written. Yes, next.
19.
Issue notice written. Yes. And the process. Yes.
19.
Whatever charge is under challenge, the present petitioner's implication is basing upon the statement of the co-accused. Case under section 20B2C of 29 of NDPS segment. Kindly see page 23 of the charge sheet. On being asked, in middle line, on being asked, he disclosed his names and address as Rajkumar.
In almost all the cases, how can I determine this at this thing? I don't petitioner.
When I pray one thing,
yes.
The who was present in the vehicle from which seizure was made, he has been granted bail.
You want me to conduct a trial like this?
No. What I'm saying,
bail. Don't go to somewhere else.
What I'm saying, only observation. Same day parity. Same day parity.
The application is rejected by.
Anticipated only dispose of order.
I should be careful while making any observation because the coordinate bench rejects the application. I can't sabotage that order.
Whatever. Subsequently, only same day parity. In the meantime, some developments are there.
Your application is rejected, thereafter you move application also, that is also rejected.
Same day parity, co-accused from which seizure was made, he has been granted bail.
Although the petitioner is seeking quashment of the CT case, CT special case number 61 of 2023, initiated against him. Arising out of Amba Vana. He has case number 142 of 2023. What is this?
And the co-accused bail from which seizure was made, another co-accused from which confession against
has already been granted bail.
Yes, sir.
Although the petitioner is seeking from but the letter counsel for the petitioner submits that he would not press this petition, rather seek liberty from this court to appear before the court below on or before 20th of December and resort to remedy available to him under law. He further submits that he further submits that co-accused had applied for regular bail before this court by filing BLA case number 703 of 2024. The coordinate bench of this court, by order dated 9/5/2024, has enlarged him on bail. Therefore, he seeks parity. He is entitled to parity with the said co-accused persons. These are here. What is 703/24 out of the 417 petitioners. Mr. Mohanty, Learned Counsel for the state, submits that the present petitioner had applied for anticipatory bail by moving ABAPL number 5503 of 2024, which has already been rejected by the coordinate bench. Therefore, therefore, he's not entitled to any relief. Regarding that to the aforementioned, I am not inclined to in this prayer. However, liberty is granted to the petitioner to appear before court. Appear before court on 20th also, and move appropriate application for grant of bail. It is open for the petitioner to raise all the points, including all the grounds, including the ground of parity. If such application is moved, central legal department.
But I mean, pardon me, each authorized same day we dispose.
Same day I have said. Yes.
Okay.
Yes.
22.
Repeat your words. In this matter, the FIR is under challenge by the father-in-law arising out of a matrimonial dispute, my lord.
Yes.
The offences under section 498A, 323, 294, 377, 506, 34 of IPC.
I'll issue notice.
Notice has been issued. Somebody has already appeared in this case, my lord.
Notice.
Yes, my lord.
Huh? Oh, okay. Yes, yes. In the morning I've taken. Nobody is there. Nobody is there. When the notice was issued? Notice was not issued.
Sorry, my lord. Notice was not issued. Advance
notice.
Yes, my lord. Sorry, my lord. Sorry, my lord.
The present is arising out of a matrimonial discord. On the advance notice, so and so has entered appearance. Siddharth Mishra so and so has entered appearance. But even on the second call, none appears for none appears for them. Learned Counsel for the petitioner submits that. What is the stage?
My lord, I do not have proper instruction regarding the for the on the last occasion I had instructed that charge sheet had not been filed. But I have to take instruction.
Charge sheet is not been.
The first time your lordship is informed.
In the interest of discharge. Yes. Yes.
Okay.
Next.
26.
Now, this is the petitioner had challenged the inaction of the police not registered case against the OP number 326.
Sorry?
The petitioner had challenged the inaction of the police, IIC Malkanagi, in not registering the case against the OP number 326.
Even in the second call, non-APS for the petitioner, in the interest of justice, urgent to March.
27.
I can dispose it up also. The what is the 26? Let us see. Why unnecessary pending? 26. Let us see. What is the
That
press?
the petitioner had filed a civil suit against the opposite party. That civil suit interim order status quo.
He is the informant. He is the informant in the case.
Informant and since they have the opposite parties unauthorizedly were occupying the land of the petitioner. He filed the 1cc case and the police is not taking action. Therefore,
then the other remedies are available.
yes,
He filed
he had submitted the representation before the SP and
Then 156.3 thereafter.
yes, sir.
Petition is seeking the.
Since that suit was dismissed from
in this petition is seeking following relief. Prayer for the following relief. Precisely the petitioner is agreed by the non-action of the police in registering the appropriate case against the opposite parties. Opposite parties. Non-appeals for the opposite party. I don't find any merit in the case because the petitioner, even otherwise, the petitioner has other legal remedy to pursue. Because therefore the present petition is dismissed. Dismissal of the present petition shall not preclude the petitioner from taking any recourse to the procedure contemplated under the code. Yes. Dispose of.
27.
Yes.
There's the allegation against the petitioner is that he has committed the offense under section 294 and 427 and 323. And the charge sheet has been filed against them. Then page 13 months. That's the attached to. ତାପରେ ଆମ ଘରର
Charge sheet has been filed or not?
no charge sheet has not been filed.
He has given some representation. What is this representation?
Representation to the authorities to take action against the accused person. One 161 statement were there. Control କରିବାକୁ ଆସିଥିଲେ ସେ ଗ୍ରାମ ରକ୍ଷୀ କଲେ ଗ୍ରାମ ରକ୍ଷୀ ବି ବାଡେଇ
Non-APS for the petitioner even in the second call. It seems petition is not interested to prosecute the present petition and it's dismissed. Yes.
28.
Please, Your Lordship. My lords, the present petitioners are the father-in-law and mother-in-law of the aggrieved person.
Matrimonial dispute.
Yes, my lords, they are the resident of Hyderabad and the opposite party number 2. They have actually challenged the initiation and maintainability of the domestic violence case inflicted upon them by the opposite party number 2. My lord, they have nothing to do with this case because it's a love marriage and whatever problem the wife is having with the husband. They are resident of London since 2022.
You are
Both the husband and wife.
yes.
The wife is working as data science manager in Lloyd Banking Group, London area, United Kingdom. I have submitted the LinkedIn profile of the wife, which is annexed in Annexure 3.
Where is the DVA petition?
My lords, it's Annexure 1.
No, she has given the Bhubaneswar address. You are giving online address.
My lord, not Bhubaneswar address. She has filed this case in Cuttack.
But she address is there, Bhubaneswar.
Yes, in Bhubaneswar, she has submitted it is Bhubaneswar.
And Cuttack
She has filed this petition in Cuttack. And the in-laws are resident of Hyderabad. Husband is working at London. She is working at London. She herself filed a petition of interim entries. My lord, may kindly see page.
What is the relief she is asking?
Page 30.
My lord, page 47. My lords, may kindly see.
What is the relief in this?
She is asking relief of several things. Interim maintenance, she has asked
Section 12.
1 lakh rupees per month for house rent.
They are arising out of section 12.
House rent in London.
She is herself, she is stating, my lord, may kindly see para 7 of page 47.
Yes, I am there.
Yeah, that besides the above, as the OP number 1 ousted the petitioner from her rented house of London, the petitioner has compelled to hire another rented house in the monthly rent of £1,000. And now she is claiming everything in Cuttack. And she herself stated in her domestic violence application in para 8.
You are the parent-in-law.
In page 26, my lord, may kindly say.
Why should the parent-in-law will pay rental for her in the London? She is staying in London. Issue notice to opposite party number 2 written also. The proceeding before the so is stayed. You can ask from the husband whatever you want. Parent-in-law, what they would stay. Yes, next.
39.
In animal, I have challenged the affair. Now, charge sheet has been submitted. I want to file it. But I will file by today, my lord itself. I will take it next week.
Next week.
My lord, the petitioner prays for quashing of the entire proceeding on the ground of compromise.
What are the offences, sir?
Offences are 147, 148, 294.
Serious offences are there. And the eyewitnesses in this
326.
326, 307, 149.
How can you compromise?
The injuries are, my lord, simple in nature.
326 life imprisonment.
Direct eyewitnesses.
They are same village, they belong to same village.
Maybe.
There is political dispute between them.
You will not burn the house of somebody else, somewhere else. Obviously, in the village only you will do it.
I got 3
Difficult.
Only 2 injuries, they are sustained in simple in nature and left arm of the informants.
Simply, I am issuing notice letters. Yes.
32.
Yes.
NDPS Act.
NBW. NBW issued.
Yes, yes. NBW issued, and that NBW issued on 5th April 2010.
Thereafter?
Thereafter.
Thereafter what happened?
It remains like it.
But you have not arrested him also.
Earlier he
Not executed NBW.
he was arrested and released on bail. Thereafter,
I know 2010 the NBW was issued.
Yes.
Why have you not executed? If you don't execute, the case is pending unnecessary. Right of petition rejected by the order dated 5/4/2010, whereby NBW against him has been issued. Though this present petitioner is the present petition is filed belatedly, our fact remains that the NBW issued by the court has not yet been executed, as a result of which the trial in 2ACC case number 9 of 2008 has been stopped in the same place. Has been stopped. Therefore, I'm inclined to set aside the order of inclined to defer the execution of NBW, subject to the petitioner appearing before the court, appearing only surrendering before the court on or before 20th of December 2024, and resort to remedy available in under law. With this observation, the petition is disposed of. Yes.
35.
Execution of also is stay or shall be kept in abeyance till 20th of December, subject to petition appearing.
Item 15 permit to withdraw registration merits records in 15 withdraw 15 pass out 1/5
ये प्लस 2 सर्टिफिकेट है जो मार्क टा इंटरपोलेट करके जो टीचर जो
What did they do?
जे तो अरेस्ट है कि बाय वर्चुअल एनरोल
withdraw
class that
may please here I have challenged the very registration of the affair which is contrary to the settled portion of law, that is in case of Priyanka Srivastava versus State of UP matter. It's a case where a complaint case was filed by the complainant with the allegation that the present petitioner, amongst whom one of the sitting serpents of the area, they protested the complainant not to.
How Priyanka Srivastava?
I am coming to, but just not to execute the lease which was granted in his favor, and by the person on a particular day, the petitioner and other persons around 15 to 20 numbers, they enter inside, they ransack, and by the process some lateral stone was taken away. So that's why offense under 395 and the other offense was filed in shape of a complaint petition. My humble submission is that because of the case under 395 has been registered, and the Priyanka Srivastava case versus State of UP, taking to this note of activities wherein false complaint case has been filed, that has resulted registration of the affair. The Honorable Court has said, while quashing the investigation of that particular case, registration of the affair in that case directed the order to be communicated to all concerned. That means call concerned register of the Honorable Court.
How?
So in the particular case also, Madam is turned to page 11.
Yes.
Sorry, page 12. This clause number 6. घटना संपर्क अन्य कौनसी थाना जणाई अच्छो कि हाँ the answer is the written reply is that हाँ घटना घटिया पर आम्भे मुदेई टांगी थाना जणाई थिलु कि थाना बाबू आम कथा को न बुझी कोर्ट रे केस करबे परामर्श देइदिले so taking note of this aspect because of the fact that he has said that we have approached the concerned police station, police has not taken any action, that's why we have the file constant to file the complaint case. In that case, it has been held that in all the cases of complaint, a separate affidavit to file by the complainant, specifically declaring.
No, the affidavit is there at
That is not there.
at the end, the affidavit.
No, this is not the FIR. My humble submission, let me see what is the in the FIR.
You know how the kind of affidavits are being filed here in this.
No, no, with all respect. It's a case, no. It's a case, my lord, where a specific affidavit, because if I will take note of that particular.
Priyanka Srivastava says that the idea of this affidavit is that whatever stated in the complaint, it has to be supported by an affidavit.
No, my lord, my humble
affidavit is given.
No, my humble submission, perhaps I am not in a position to give a clear picture. Priyanka Srivastav's case, my lord, has been held by the apex court that in each case there will be separate affidavit declaring the fact that in which date you have approached the concerned police station and under which circumstances you have approached the police station and what are the contents and if it has been sent through registered post. Registered post.
One of the paragraphs says, but if here in this case it says that you have the police has advised him to do it.
That means they have approached, my lord. They have to my humble submission, they have to clearly specify that on which date they have been because a separate affidavit. If I take note of this particular, I'll also place that particular thing.
I know, I read
that. It's a separate affidavit. Not each and every case as per the GRCO. Each and every case as per the GRCO, affidavit is to file. That was there and it is continuing process. It is to file.
See, supporting affidavit is already there.
No, my lord.
No,
each and every case.
I know, sir, but see. The problem is the quality of the pleadings in the court here. You have seen.
Yes.
The kind of affidavit being filed here, you have seen.
My lord.
It is coming from your office also.
Yes, my lord.
So the same, that is what is happening.
My humble submission.
If you start interfering in this kind of situation, then there will be no
But in that particular Priyanka Srivastava case, because of this,
I know the order is specific. You have to give a declaration. The idea is 154.
A separate affidavit.
154 FIR is not lost. 155 you have to follow. Then 156,
yes.
2, 3 and everything.
Yes, madam.
That's the idea.
Yes. But my humble submission, because of the fact.
Okay, I'll issue notice, let us see. There is a matter to arguable case. Issue notice. Arguable.
Only may pray, madam. Because of the fact. Yes, I am opposite party number 2 requires by to only may pray because of these things were coercive action, may pray, no coercive action. Is there. And what is the allegation? That we have taken out and broken some laterite stone. Let me see that is the allegation.
What are the allegation?
Laterite stone. Laterite stone has been broken and taken away.
Not only laterite stone, also some other things are also.
How kitchen? Let me see page 13.
Oh, so many people.
एक कथे तो हुई हम खणी भी लिखा तो कथे जोर जबरदस्त प्रवेश करी फलक चिन्ह जोटा कि थाए ताकू भांगी देले এবং आसपत्र भांगी देले 200 पत्थर बाड़ी भांगी देले laterite stone उड़ाए.
No, investigation is still going on. So what can I do?
No coercive action.
No coercive action 438.
So because of this, my lord.
438, no coercive action.
So I do consider that.
What's
village dispute, my lord. These are the resultant, my lord. But take it 2 weeks after, 3 weeks after. And this, no.
No, issue notice, no coercive action.
395 only go and all of this go. 395, my lord, how it will be materialized? Doctor, I think.
Therefore.
Yes, ma'am. That's why. My request 379, my lord.
Since the banner is that more than 20 people have entered. So the
rather, my humble submission is that my state council will also consider that 20%. There is a free possibility of making a.
Take instruction on second. 5 seconds. Second, I am listing it on second. It can be settled. Allegations are not much serious.
They are also mentioning that there is a civil dispute between the.
So therefore, take instruction, ask the IO, then I will protect and finish it up. Okay, second.
And may I pray? Madam, may also call for a report from the concerned of the
court. Status report too.
Status report. Let there be report from the concerned courts whether there is separate affidavit has been filed.
No. This is you have to make out a case. I can't. Yes. You file any petition, then I'll start inquiring. Collecting documents from where and.
I'm not on that. My humble submission.
That I'll not do.
All right, man.
This practice you have to stop.
No.
You file anything in the court and they say, ask from him, ask from them, and to substantiate your case.
I have special.
You have to substantiate.
I have taken ground.
The kind of petitions are being filed, it is very hopeless.
I have taken down.
You don't find any document, you can ask him.
Because that will, hey, my lord, it's all right.
You have to substantiate Praman Pachai.
At times because of the
Second, let me see, I want that it should be settled. There is nothing in this. Allegations are not serious. You ask the IO if something can be done, we will finish it up.
all right.
Yes. And in the bureaucracy, strictly if you go na, I think in Orissa, no case can be registered in one.
In such a case where the Apex Court in the year 2015 has passed the order, communicated to all register with the direction to communicate to all concerned courts, and the court has to abide by that.
No, it has to be communicated to the lawyers also.
Lawyers, well, but
the lawyers are doing this.
Yes.
What court will do?
But with all respect, if the court will put the art in a such a manner, strictly it will be improved, but that it will be materialized.
Then we know, then almost all the cases of yours will be dismissed.
That will
when you come to this court for watching a pilot on the ground of settlement.
But with the advocates always found the way to how to come up with all sorts of things.
But it has to be, you people have to make the lower, the younger bar know about these judgments. The quality, see, these are, the litigant doesn't do it.
Yes, obviously.
It is the lawyer.
Yes, it is the lawyer. The moment the court will say ask for this and that to be materialized, then definitely the advocates will materialize it, my lord.
But it should be carefully drafted. That's all. Yes.
47. Passing of proceeding on the ground of settlement and more so, my lord, the ingredients of the offences are not made out.
Either settlement or ingredient. Settlement
ingredients
376.
Yes, my lord. Against brother-in-law. And my lord, look into the
Where have you said that settlement and all?
Running page 23. Annexed to 3 series. Statement of the informant victim, my lord.
Yes.
ମୋ ନା ସମୀଲ ବିବି ଆପଣଙ୍କୁ ସୁଆଂଶ ଦେଉଛି ଯେ ମୋର ସ୍ୱାମୀ ଶେଖ ସୁଆଂଶ ମୋ ଦିଅର ଶେଖ ଫିରୋଜ ଖାନ ପିଟିସନର କଥାରେ ପଡି ମତେ ଯୌତୁକ ନିର୍ଯାତନା କଲେ
376 ମିଳାମିଶା ହେଇଯିବେ
ସେ ନିଜେ କହିଲି
The petitioner is facing trial under section 20(b)(2)(c). During pendency of the violation, the wife of the petitioner has become serious. Last time, directed State Council to take instruction regarding ailment of the wife.
Ailment of
wife of the petitioner.
Wife of the. You have moved interim application?
Yes, my lord.
Where is that?
IN number 1419 of
notice was issued in interim.
I may pardon.
Notice was issued in interim application, right?
1419.
Petitioner has IN number.
1419 of 20.
1419. Petitioner has moved the interim bail, the present application seeking interim bail for a period of.
And I pray.
For a period of 4 months.
Prayer is for 1 month. I pray because the condition is very.
You have asked for 1 month. What can I do?
No, I Marital has every power.
Interim order for 1 month. Interim order one. Don't write 1 month. Everywhere you write 1 month. Interim order, interim relief, interim bail on the ground that his wife is seriously ill. Therefore, he has to attend his wife. The instruction was sought from the investigating officer, who the inspector of excise, Sambalpur, by instruction dated 16/11/2024 has stated as under para Rita. Regarding head to the instruction received from Inspector of Excise also, which is reproduced here above, I'm inclined to enlarge the petition and surrender before the court. 6 weeks. Main bail application withdraw to renew on the changing circumstances. What is the disease, by the way?
10 kg of
urine output and nephrology consultation, urine methylated. Kidney related problem. Methylated. Madam, if possible, urgent copy. If possible, I say.
What?
Urgent copy, if possible.
Yes, yes, today only, today only. Yes. For the, yes.
65.
Yes.
During pendence of my first bail application, charge sheet was filed on 25/5/2024.
25?
25/5/2024.
Yes.
Under section 498A, 304B, 306, 406.
You are in custody since?
Custody since 1/3/2024. 1st March 2024.
Yes. Show me the allegation.
But 498, 304B, 306, 406. and
Yes, yes,
404.
okay.
And that bail application in lordship dispose of granting liberty to the prisoner to move after filing of charge sheet. But because that during pendence of that bail application, that was filed. Now after charge sheet, my lord, I have come up before your lordship. The entire case based on two facts, my lord. One is property. The second is suspecting the character of the offender with relationship with her sister-in-law. This is the statement of the each and everybody.
What happened on that day?
Yes, exactly. I am coming to that. And on that day, the husband had been to work in the tent house, marriage tent house. He came at late night. There was a quarrel between the husband and the wife because he was drinking. Drunk state, and he slept on that. All night slept. But when he woke up, he found his wife hanging from the room. She was hanged. ସକାଳୁ ସକାଳୁ ତାଙ୍କ ଘର କାନ୍ଦୁବାଳି ଶୁଣି ମୁଁ ସେଠାକୁ ଯାଇ ଦେଖିଲି 3/5/2024.
And this
3/5/2024.
And this court has disposed of the 11/9/2024, giving granting liberty to the petitioner to renew the bail plea after the charge sheet is filed. Initially, the FIR was registered for alleged offence under section 498A, 302, 304B, 34 IPC, read with section 4 of DP Act. After investigation, charge sheet has now been filed for offences, alleged offences under section 498A, 304B, 306, and 34 IPC. Read with 406. 34 IPC. Read with section
406. Only husband has been charged and all other have been discharged.
Okay. No. Then 498A, 304B, and 406. 306, 406. And DP Act also. 4 DP. Previous before DP Act. The statement of the independent witnesses recorded under section 161 CRPC has been extensively read over. Particularly the statement of one Ramesh Bera, who is stated to be the neighbor of the petitioner, has in Australia stated that on the fateful day, the petitioner came from a party and was completely drunk. He had an altercation with his wife.
Get irritated. Get irritated because he was drunk.
And then he slept over. In the morning, when he woke up, he saw that the wife of the petitioner has hanged herself. Hanged herself. And the suicidal nature of the evidence further reveals that the wife of the petitioner has committed suicide out of frustration, and because of the continuous torture meted out her. The petitioner is in custody since Petitioner is in custody since 1/3/2024. The charge sheet has already been filed in the county, and the trial has not yet commenced. And there are how many witnesses?
Only number of witnesses.
Number of witnesses.
And they have given flag who is the charge sheet.
There are 25 witnesses cited by the prosecution in the charge sheet. Therefore, the trial is likely to take substantial time. Regard being had to the aforementioned, I am inclined to enlarge the petition on bail accordingly granted. Yes. Okay.
66. The report was called for application only for interim bail.
Yes.
But it is not common.
Next week. Second.
Monday.
No. Interim bail, otherwise the purpose is defeated, no?
Purpose.
Huh? Oh, what are the grounds? Interim bail ground?
He has complications arising out of heavy typing.
That is, but the rejection order indicates my lord. Yes, 40 my lord. Seriously, it will be detailed question. This is the my lord, submission before the court. The court was called for a report. And a 41-year-old assistant. Pradhan is suffering from type 2 diabetes, melteous, and his present health condition is stable. This is the condition before the Lord and trial.
Now you get a fresh this thing. Okay. 4th or 5th?
4th, past
5th. Right.
67.
Okay.
Please, your lordship.
May I actually, what are the offences, by the way?
302, he is the main.
I'll grant 1 week and ask him to.
The report as well.
Okay.
Because this is the main issue.
The main issue. Yes.
67. May I please, your lordship?
Yes.
This case is arising against the bail application number 6459 of 2024, which was disposed upon 7/10/2024 with an observation by your lordship to review the bail application before the learned court below. And on 9/10/2024, the petitioner reviewed his bail before the learned trial court, and the learned trial court, after hearing, pleased to reject the prayer of the petitioner, hence this bail application.
Yes.
This is a case under section 302 IPC, your lordship. And the petitioner is in judicial custody since 17/11/2022.
Yes.
Allegation is that on 16/11/2022, the informant submitted a report that his nephew Abhishek Khamari had been killed by the petitioner by means of Tangia, and which was seen by one Prakash Behra and Anil Sabu. Your lordship, please
Have you seen the evidence of the material witnesses?
Your lordship, what happened in this case, out of the charged witnesses, 6 are common witness. Apart thereafter, only 24 charged witnesses are there. Last 15 witnesses examined till 15 May 2024, your lordship. In the meantime, already 5 months already elapsed. Another 3 to 4 witnesses have been examined. Your lordship, call for the status report. What happened? The other witnesses have been examined or not? But here is the case, PW 8 and 13, already clearly, lordship takes the name of the present involvement present accused person, lordship. I am pressing the PW 9, your lordship. Who is the informant? Akash Kumar is my co-villager, your lordship. Mahabir Pradhan, your lordship. He is the co-villager. The statement in his examination sheet has clearly stated that I know the accused Chintamani Shau, UTP, who is standing in the dock, is also my co-villager. I know the deceased Abhishek Kumar, who is the son of the I occurrence took place and so on, so in the big side of the dealership. There I heard the notice Maridella. So I rushed to the spot and saw the accused was running away from the spot with a blood-stained Tangia in his hand. I saw the body of the deceased was lying on the ground with cut injury on his neck. The depth of injury was PW9, your lordship, that is Mahavir Pradhan, your lordship.
Yes.
And PW 13 also, though
there are eyewitnesses.
So yes, your lordship, it's clearly tested the name of the present application, your lordship. And apart from that, your lordship, another witness also, PW 8 also, your lordship already supported the case, PW 8, your lordship. Prakash.
Yes, Mr. Lal, how will you get over these evidences which has come on record against you?
Sir, the whole case is standing over the witness evidence of the eyewitnesses Prakash Behra and Anil Sahu.
Yes.
Prakash Behra turned out hostile and he stated that he heard about the occurrence from the villagers.
Who has done hostel? Prakash
Who is
Bera.
the PW 8?
Oh, what about PW 9?
I'm emphasizing
9 and 13.
PW 9 in his cross examination, Your Honor, may kindly peruse the house of Ratni and Jehru, situated 100-meter distance from the spot of the occurrence, but the IO has not examined the said person. And he stated that in his cross examination, sir,
Which part of the cross examination?
sir, in para 6, of his cross examination of PW 9, he stated that the house of Ratni and Jehru, situated 100-meter distance from the spot of the occurrence, and same is within the audible distance from that place.
Yes.
Then?
But the IO has not examined the said persons. Sir, in
No,
this case,
that is IO, I don't know. IO has not yet been examined.
they have not been charge sheeted witness, sir.
IO has not been examined. You don't think you have a case? Petitioner is accused in FIR number also. The trial in the case is proceeding in the expected pace. How many witnesses are examined?
Total 30.
One minute. Out of 30.
Out of 30, Your Lordship. 6 are common witnesses, the seizure witnesses, Your Lordship. 24 witnesses are there. Out of 24, till May 2024, 15 witnesses have been examined.
Out of 24 witnesses, 15 witnesses have already been examined. And PW 9 and 13 are the vital witnesses, eyewitnesses. Those are vital to the prosecution and the eyewitnesses. They have categorically implicated the present petitioner. Hence, at this stage, I am not inclined to enlarge the petition on bail. Accordingly, the same is dismissed. Yes. Next.
68.
68, Your Lordship. Yesterday, I received the copy of the case diary, Your Lordship.
The double model, Lordship, there is case.
We will read it next week.
Let it be going through the same, or also let it be
Next week, yes.
And 70.
Madam, date will next week. Next week.
Yes. 70, kindly take it to one.
Adjourn on request.
71.
71. Okay, so 71.
My lord.
Yes, Miss.
My lord, intervention application filed by someone else. Matter has been disposed of by your lordship, referring it is to mediation. Accordingly, the matter has been disposed of. Now there were in fact, your lordship, 4 sisters. The sister-in-law is having some dispute with the 4 sisters. Against 3 of them, she has lost the affair. Your lordship has referred the matter to mediation. In mediation, it was successful. So they have a family settlement.
What? I can dispose it up on the terms of mediation report.
That is already disposed of.
Then what happened?
Intervention application is filed by the 4th sister, who was not a party in the affair. She is saying that 3 sisters and the sister-in-law, their matter was referred to mediation. I was not there.
Oh. You are appearing, Mr. Nanda? Who is appearing?
Your Lordship, I am appearing for the petitioner, Your Lordship.
Who is appearing for the intervener?
So, Your Lordship.
Non-NDPS for intervener. This is an the matter has already been disposed of.
Yes,
by the order dated 20th March 2024. 24. In terms of the mediation report. Subsequent thereto, the present application has been filed by one of the stakeholders who was not party to the criminal proceeding. Issue notice to the petitioner the application, release the matter in March, April, May.
Your Lordship, if I may submit, Your Lordship.
Hmm.
Your
You
Lordship,
can't
see,
declare this is frivolous unnecessary application. I have already discussed up on this. Yes.
yes, Your Lordship,
May-
Your
may-
Lordship, I'm praying that.
He was not a party to this criminal prosecutions. Nothing is there. How can you get an application like this?
So your lordship,
praying that such
so your lordship,
application is
his
dismissed, Your
so your lordship intervention's prayer is that he should be made an accused in the criminal case, and that thereafter, your lordship.
It will come in April.
May I pray, your lordship? May
Your
I pray,
Lordship,
my
may
lord?
kindly allow me to submit, Your Lordship. Your Lordship, if this IA is not dismissed, Your Lordship, they are taking this plea to prolong the proceeding before the lower court, Your Lordship. They have said that we have filed an IA, let the case be pending, whereas there is an order by this honorable court that the
71. 71. Are they taking advantage of this pendency of this application?
That is not within my knowledge. May I pray, my lord?
Are they taking advantage of the pendency of this application somewhere?
That is not within my knowledge.
That's what Mr. Nando is saying. Then it has to be disposed of.
May I make a submission, my lord? Since
Yes.
he is not there, your lordship may dispose of granting liberty to pursue their remedy as available under law. Yes, sir.
For the reasons stated in the application, for the reasons stated in the application, I am not inclined to entertain the same in this in the present proceeding, particularly because of the reason that the criminal MC has already been disposed of on the basis of mediation report. However, dismissal of the application shall not preclude to the petitioner, intervener applicant to resort to any remedy available to her in law.
Yes,
With this observation, the application is disposed of. Yes. 73. Yes. Yes.
Question of Annexure 3. Annexure 3, page 28.
Is there any? There is no stay. None appears for the. Yes. Yes, sir.
Lordship, I am for the item number 73, my lord. 73. May I please, your lordship?
Yes.
Petitioner have filed this case for passing of NBW, my lord.
NBW?
Yes, my lord.
Where is that order?
Lordship, kindly glance to the page number 29, my lord. In the last paragraph, my lord.
Last paragraph. Where is that? Read it.
This NBW against the said accused person fixing accused by the accused production.
So order split up.
Yes, my lord.
Read it. Where is that?
Lordship, page number 29, my lord. NBW has been issued against the petitioner, my lord.
I don't see
Letter
part, my lord. Last paragraph.
As per the above order, the split up of the file against the accused person named so and so, Lordship Director, issue phrase NBW against the said accused person fixing 21/12 and 21 for production, Your Lordship. That is
how many of them are there?
Your Lordship, here is the present accused person are 20 numbers, Your Lordship. And
20.
Here is the NBW issued against 1, 3, 2, 3, 4, 5, 6, 7, 8, 9, 10, Your Lordship. 11.
How many petitioners are here?
My lord, 13 petitioner, my lord.
Manapur, huh? What are the offences?
Lordship, the offences under section 307, my lord. Along with other offences.
You appear on 20th, huh? 20th of December. Let them appear in 20th December. Otherwise, you keep on searching them. If they are voluntarily coming and appearing, let them appear. You know, petitioner is agreed by the order dated. Petitioners are agreed by the order dated 2/11/2021, whereby NBW has been issued against them for their non-appearance in.
Lordship, I am not in bail, Lordship.
I know you're not. NBW has been issued against them for their non-appearance. The petitioners, the counsel for the petitioner, on instruction submits that his clients, the petitioners would be appearing before the court, surrendering before the court on or before 20th of December 2024, and resort to the remedy available to him, available to them under law, subject to petitioners appearing surrendering before the court on or before 20th of December, so and so, and paying cost of rupees 500 each to Banapur is a district? No.
No.
Which district court? Banapur, there must be a there must be a bar association.
Yes.
Banapur Bar Association, welfare fund of Banapur Bar Association. The execution of NBW issued by the court below, by the impugn order dated 2/11/2021 shall be kept in abeyance. You appear on 20th of December and resort to remedy. Till then, the execution will be kept in abeyance. Yes.
Yes, the petition will be released on the.
That court will decide.
Sorry, my lord. Otherwise,
that court will decide. 3/7 you will get it. Yes.
That's permitted to do.
Yes, next.
74 and taken out. On behalf of DR Mishra, yes, now no more. No more. Dullabh Ranjan Mishra, the advocate is no more. And today I have received the file.
Okay.
Any other
on the request, yes.
75.
Notice.
Please, your lordship.
Notice
Item
was
75, my lord. Lordship, I am appearing for the opposite party number 2, my lord. Informant, my lord.
Opposite, Mr. Khandar. Mr. Abhishek Khandar enters appearance for opposite party number 2. The counsel for the petitioner seeks an adjournment in the interest of justice adjourned. 76, yes.
Lordship, direct to serve a copy of the application, your lordship.
Yes.
My lord.
76.
May I please, Lordship? Just under my lord 21C NDPS Act, my lord. And the petitioner is a 50 years old, my lord, and the falsely the petitioner is a drug-added person, my lord. Drug-added person, my lord. And falsely the implicate the police, the custody, my lord, the petitioner. And the main no seized, my lord, any of the vehicle, 2 vehicle in the Soumya Ranjan, Baliar Singh, my lord. Principal accused.
Investigation is going on.
My lord.
Son, go and participate. I'm a petitioner checking crossing up for the FIR for him, crossing up FIR number so and so for offense under section so and so for him on various grounds. Investigation is still going on. Therefore, I am not inclined to entertain this petition. However, liberty is granted to the petitioner to apprise all the facts as narrated in the petition to the investigating officer, who shall take into consideration the same in accordance with the law while filing report under section 173 CRPC. Yes, next.
77.
My lord. And the
77?
My lord. Yes. Victim and the petitioner. My lord, already amicable settlement in the villager.
Minor.
No, amicable settlement.
Maybe amicable, but the judgment is clear. What to do?
The bail application, my lord, annex 2, my lord. One.
Bail application, forget the bail application.
And the.
He's 7-year-old girl.
My lord. Today, my lord, 13 years old, and the victim, the informant.
13 years, what will do?
Settlement, the party, my lord, CLMC number 3501, my lord, already.
Simply March, yes. Next.
78.
Deployed.
Twice I have taken notice. Twice I have taken notice, my lord. But I have to take through paper publication.
Service question.
Concerned postal endorsement address can be created.
Last जोटा complaint petition अछि से notice नहीं थिले सटी फेरी गैसला nobody present में लो second मु search माने कोरी कोरी जान ली से पर native village रो से native village रो मिली
through council sir
through I will paper publication करी सटी
through council is prosecuting the complaint against you through council.
Yes,
despite repeated attempt made by the petitioner to serve opposite party number 2, the opposite party number 2 could not be served. The last postal report endorsement indicates that
Address can't be located.
indicates that the address could not be located. In these circumstances, petitioner is given liberty to serve the opposite party number 2 through counsel appearing in the court below, appearing in the court. Release the matter so and so, interim order to continue. Yes.
May I please allow it? So I filed for modification of order, Lordship. On 12/11/2024, Lordship was pleased to dispose of the application and liberty granted to the petitioner to surrender in the trial court and move the bail, and same shall be disposed of by following the principle of parity in the same day. But in the order, Lordship, para 5, the same day disposal part is not there.
Para 5?
Para 5 of the order.
Where is that order? Where is that order?
Original.
Where is? Show me that order.
That is 12/11/2024.
Where is that? In this file, it is not there.
In this file, the order.
No, it's not there. What is this application is about?
Only the modification.
No, where is the order? The original file.
12/11/24 original order. 12/11/24.
Which part you are talking about?
Para 5 of the order, Lordship, direction part is there. Lordship directed to if such an application is moved, the same shall be considered on its own merit. Only I pray, Lordship, with the
only.
Yes. Otherwise,
petitioner in this application has sought the modification of the order dated 12/11/2024. 24. For the reasons stated in the application, the same is allowed. The petitioner is allowed to. That date is also gone.
Yes, 15 days.
Petitioner is allowed to surrender, appear before the court below on or before 20th of December 2024 and resort to the remedy available to him under law. If the petitioner is also granted liberty to move application for bail, raising all the points, including the point of parity. If such application is moved, same shall be considered on its own merit on the same day. With this modification, the application is allowed. Yes.
80.
Mr. Mohanty.
Yes, sir.
Actually, notice address is absent deliberately. Both of them are staying in the same place, but deliberately he is avoiding to receive the notice.
It is left.
This is always absent.
Always absent.
Always absent.
Both are staying in the same place, same house. Any of my lord, face capable lordship.
Always absent, huh?
Jone pa ye jao jone rakhuni apu.
Okay, right on. The repeated attempt by the petitioner to serve opposite party number 2 has held no result. The result of which no result. The petitioner is repeatedly the postal attempt to serve the opposite party number 2 has repeatedly been failed, as the petitioner, the opposite party number 2 is remaining absent from the address given. In the light of the judgment of the Honorable Supreme Court, in that judgment is there. So the service on the opposite party number 2 shall be treated sufficient. Means the matter for disposal. Interim order to continue.
Obliged.
One.
In the last occasion, your lordship asked to serve a copy.
Yes.
To the Vigilance Department Council. We have done that.
Yes.
Whatever, in the last occasion, your lordship was ready to dispose of the matter to target the case in the trial court
because this petitioner, he has already, he has so much of complication, medical complication like bypass surgery, then gastrointestinal operation. You are agreed by what? Target the thing. Target the case.
But, Lordship, this was before a Lordship board last Friday nights. I was desperately praying for a copy notes. My learned friend was not inclined to give me the copy, saying this is only 205 application, only person this way, nothing to. But I insisted that my department has a right to be informed. Give me a copy. Today is good enough to give me a copy of notes. This is a clear case of misappropriation. A challenging an order rejecting this is
No, he is not on merit. What he says, expedite the trial because he is suffering. This is
what is the document?
This is purely a human rights violation. But where have you said that you are suffering anything?
No application 205.
In the petition, not 205, we have already annexed the medical documents.
And too much to indicate your complexity.
Where is that medical document? Yes, Annexure 4. Annexure 4.
90 notes.
Page 90. Let's see. Millard, it is page number, Annexure 4. That is in frame?
90.
Millard.
Please misleading Millard. In fact, the case was posted on 11 January 2023 for framing of charge. 23. That I have to abstain whether in the meantime charge.
Petitioner is accused in FIR number so. He seeks quashing. He seeks. Although he is seeking quashing of the entire criminal prosecution initiated against him.
Against an order rejecting this application.
No, there is no application. Seeking.
Although he is seeking quashing of the entire criminal prosecution in his
arising out of Hon'Ble Vigilance PS case number 7 of 2011, pending in the court of learned ADJ come Special Judge Vigilance Sundargarh. However, he submits that in view of the serious health condition of the petitioner, the trial of the case should be directed to be concluded expeditiously. He has relied upon the medical document placed as in the annexure 4 of the petition.
2016.
4 of the petition. The trial court proceeding indicates that charges have already been framed and the matter was lastly listed on 13th of 11/11/2023 when the charges were supposed to be framed. Since 1 year has already left in between. Nothing is coming forth in the record to suggest to indicate what is the status of the present case. Be that as it may, the petitioner.
The medical certificate 2016.
Be that as it may, the fact remains that the petitioner is a 69-year-old person and appears to have been suffering from various ailments. Therefore, being an accused, he has a statutory and constitutional right of free, fair, and speedy trial. Therefore, it is expected that the trial court should do well to see that the trial is concluded as expeditiously as possible.
One more submission, humble submission, because the petitioner is staying in Jagatsinghpur. The trial court, it's at Sundargarh. It's far up from the place, and
all the see, you want an experience disposal, you have to cooperate with him.
Once I'm committing, his interview, which is not the correct decorum of the court. What do you want? My humble submission is that this petitioner unable to move at this age, and the
you can
The same thing kindly reflected.
The problem is not the see, I'll tell you, the problem is once you say that expeditious disposal, some order is passed, you seek adjournment, I can't come and I can't go, then
Not like.
delay.
Not like.
You can't have both the things.
Through BC.
No, that you have to make application. You make application. Liberty is granted to move application before the trial court. Trial court making. I will not say anything. I have not preempt everything. For trial court to
Let it concluded within 6 months, my lord.
you move application the trial court.
Okay.
In dispute. Wait. Let us see another chance. Yes.
82.
Marital lordship, my lords.
Yes, sir.
This application 482 is directed on the order of cognizance under section 15 of the Environment Protection Act, my lords. Now the annex of 2.
Yes.
At page 19.
Yes, sir.
PR received under section 15 Environment Protection Act against the accused J.N. Patnaik, cognizance and offense on 15 Environment Protection Act taken. Issue summons.
Yes.
I have challenged that order, my lords.
Yes.
First of all, without going into little merits of the case, while pendants of these cases, the common case disposed of by the Honorable Appeals Court, my lords. In their judgment, where I am the party also, the Honorable Appeals Court held the mining operation in violation of EP Act, FC Act,
yes,
entitles to penalty. So it's a penalty course after with compensation. That compensation I have already paid 123 crores by your additional.
So the offense will not go away like that.
The offense
only because you pay the penalty.
So that's what I have to go on. No, as a direction of Appeals Court, my lords, I pay the penalty, my lords. Not that you on your own, but it's the government assessed.
But the offense remains.
Because that period of allegation is there for that period.
I know that. I know.
May I place the common judgment, my lords?
I was party to that.
Yeah, petition was there also.
I appeared there.
So this way, imposing penalty.
Penalty will not take away the offense.
No, it's a penalty means
you might have paid it. What to do? 100% you might have paid.
Look, so what Honorable Appeal says, it should substitute compensation. The offense is
compensation for illegal mining. To that extent you have paid. But the offense, how the offense will go?
The offense says, my lord, section 5 says, either punishment by way of imprisonment or fine.
That is a different, that is the towards royalty and all.
No. Section 15 of EP Act, my lord.
No, that common cause you have.
No, EP Act. The value of mines, the ores extracted, entire 100% value. That is not the royalty alone.
No. Many mining owners are facing criminal procedure. What to do?
Anyway, some cases you
show me any case it's quashed because of common cause. Show me one case.
Common cause the first time, or before that something is quashed.
Before that, forget over. And that on the ground that after common cause you have paid the 100%, and thereafter the criminal prosecutions are quashed. Show me one case, I'll do it.
One case, I'll sort it.
That's it's not.
I have one merit also.
Merit you have a case. You tell me. Merit I can examine.
Merit was meant under 2006 year notification. I have not obtained the clearance, my lords. That was the allegation. But mining operation stopped.
That time it is counterproductive. The fact that you have paid penalty as per common cause, you have admitted, pleaded you are guilty to that.
It is not pleaded.
I am saying.
Honor Appeals Court order.
It is a counterproductive.
In 2006 notification,
I don't think you have.
I have not got the clearance of penalty. So to paying my miners closed, my lords. After payment of this compensation by order of Supreme Court, the miners were resumed by order of Supreme Court.
You show me one case where it is quashed.
You have to.
They have
to sort, my lords. The number of cases you have here.
And simply, yes. If you can get some parity, then
No, again, my lord, I also plead my double jeopardy, again penalty, again compensation, both what they, double jeopardy. So
Therefore, I'm saying if you can get some orders
on double jeopardy
judgment.
Case of double jeopardy. I have paid the compensation, my lord.
Compensation
100% value of the mines oversight extractor.
Compensation is not penalty in lieu of section 15.
I must not only appreciate.
You get some judgment, you don't have a case prima facie. If you can satisfy me by getting some judgment,
I want, that is also I will address my lord.
Yes, next one.
83.
My entry mode is there, my lord.
Entry mode to continue. Yes. '83. Yes, sir.
May I please yours? Not petitioner. There are petition number 1 is the president and petition number 2 is the secretary of the society.
Yes.
They now the challenging the order of cognizance running page 15 on order dated 25/8/2014 under annexure 2.
Yes.
Offense under section 126, 135, 130 of the 138 of the Electricity Act. But if Lordship will kindly have a glance to the FIR mallet first.
Yes.
FIR is drawn by the electoral official alleged in the FIR column. Lordship kindly have a glance. Running page 9 is only one accused who is the builder. Lordship got it, mallet. Running page 9. Running page 9.
Who is managing the society?
He is the builder. Yeah, Lordship, kindly have a glance to the FIR, small FIR.
Forget about who is managing the.
He is the builder. He mallet while hand over the building mallet. He mallet some allegation that some one number of connection to the STP plant and to home. That is the normal.
Generally, what happens? Builder construct the building. Thereafter, handover possession is handed over to the members.
Yes.
But the management of the society
what
builder.
What happened, mallet? Initially, while constructing mallet, building mallet, usually mallet builders used to take mallet a connection temporarily for a construction. Thereafter, he has to install
I know
connection for all mallet. So during the initial day mallet, when there is no connection, so that he took connection to the STP plant and another without installing mallet electricity transformer. So how the manager is the petitioner or secretary and president.
We have to start in construction from the.
When you took the possession?
Mallet
which year?
Possession.
You tell me, give me the dates. That is relevant.
Data relevant to data set CD reflected exactly quite probably data. But whole thing is that mallet.
Which year at least tell me?
It's in the 2014 probably mallet. I'm not sure.
When the FIR is
FIR of 2016. No. FIR is of 2013. 13 रे हमको देले construction करी.
Just I want to know whether this FIR is registered before taking possession or after taking possession. Why don't you give me the right dates?
Then you want to argue defect. I'm sorry, mallet. I don't know. Real possible put this question to me. This is obvious question. Obviously, one thing, mallet.
This is an obvious question because your case is builder has constructed the society, given it to you, all the members. You are the president and secretary you elected.
That is the allegation.
That is the allegation. Management is being controlled. Management of the society is being controlled for some time. 1 year or 2 years, there is a contract condition. That is also I require to know. Because there is a contract condition. The management of the society is generally carried out by the builder for some time. 2 years or 3 years. Period thereafter management is given to the society. That is the rare principle also.
What happened, mallet? FIR was registered against the builder. They found that this consumer number is in favor of the builder. Thereafter, during investigation, mallet they submitted charge sheet against the
because the case is management is given to you. You tell me when the possession is taken by you.
Possession or date सोमवार ना पर दिन रखो मुझे दे दे पर दिन ना काली रखो काली मैं कह दूँ जो पोजीशन डेटा
for tomorrow only for
instruction
and one more date for another date.
नहीं
Kali, sorry.
What kind of argument you are enjoying interim order, you don't have the facts.
Fact regarding the possession, I'm not.
You don't have it. I'll vacate this interim stay and come after 2-3.
No, Your Lordship will dispose of the application. Your Lordship, tomorrow Your Lordship put, I will satisfy Your Lordship's query, this query. But in fact, I am not aware of the which date.
These are very obvious things.
That is
very, very obvious thing.
But the FIR allegation is that in the FIR, the officer alleged that they found during our visit to Metro Satellite City for inspection of the meter in presence of the officers, electrical officer.
Where is the charge sheet?
Yes. It is found that
Charge sheet.
Charge sheet I have filed, my lord.
Yes. Show me.
Subsequently, I filed the copy of the charge sheet.
Don't want to make out a case. So I'll not adjourn like this. Show me.
I filed, my lord, the copy of the charge sheet.
Yes.
I filed on 22nd October 2024. Right.
Then the charge sheet is written. Just see. You have not read the charge sheet. Have you read the charge sheet?
Charge sheet, my lord, no.
Have you read the charge sheet?
What is?
Okay, now you are reading. That's the question which I am asking.
Yes, sir.
He says that the builder has taken the connection.
Yes.
And he was paying regularly the electricity. Thereafter, the flats were handed over to the owners, and the owners form a society. And thereafter, they stop paying the electricity, and that is why the theft has taken place. The entire liability is on you. And rightly the charge sheet is filed. Right on. Right on. You
President, we are
trying to mislead. Right on. Petitioners are the president and secretary of the Metro Satellite Ooty Complex Society. An FIR was registered being FIR number so for alleged offense and defection. In the FIR, the allegation was made against the developer who has constructed the society, housing society, that he has illegally and taken the electricity. So on. After investigation, charge sheet has been filed in the present case. The charge sheet reveals regarding being had to the fact that the investigation has taken place, and the charge sheet is revealing a prima facie case. The prima facie case, I am not inclined to entertain the petition on merits. However, liberty is granted to the petitioner to raise all the points before the court below at the appropriate stage.
Well, I'll raise all the points.
All the points you raised before court below.
Before the court below.
You have not read. That is the only point I am asking.
No, what happened?
It's exactly the same point I was investigated.
No, before that, they have approached the authority.
You have not read the charge sheet. That's the whole difficulty.
No, that is not
seeking quashing, but without reading charge.
That is here not specifically that mentioned, madam.
That is what I am asking. You are not able to understand. That is the precise question. When you have taken position.
After stoppage, my lord, what happened, my lord? They approach the authority.
Anyway, you argue all this point.
My lord.
Yes.
Lordship, you have observed that I will.
Yes, you argue. I have given that. Yes.
Raise on the point at the time of framing of charge, ma'am.
Yes.
84.
84. 84. Would you be yes? Yes. Peremptory order was there on 4/11/2024. No further adjournment shall be granted. Because on 4/11/2024, the following order was passed. When the matter is taken up today, none effect for the petitioner. Therefore, the petition is dismissed for non-prosecution. Yes.
85.
I'm for the petitioner.
Yes.
But I've been requested by the counsel for the opposite party that she has some personal inconveniences today. So, if your lordship is
on the request of
December 5th,
Mr. Otto, lease the matter on short. Yes.
interim order to grant.
Interim order to grant.
86.
It's made clear that no further adjournments on whatsoever ground shall be granted on the.
I'm not asking for the adjournment.
Whatever.
I'm for the.
Now it is.
Plus.
86, I need some time. 86.
Under payment of wages that Cognizance has been taken, where they have admitted in their counter that entire payment has been made.
Yes.
Anyway, it's a new since the new.
2021 interim order is there. Yes. On the request of land council for the state adjournment of so and so, the interim order to continue. Ticket later they do. February.
87.
Which is it?
Item 87 can taken up tomorrow.
Tomorrow.
That's
why.
Learned Singer has some difficulties for
Adjourned to February. Yes. On
interim
which-
order.
It will go to February. Yes.
88.
Lots of interim order is there.
There is interim order.
Lots of.
Oh, interim order is there. Oh, 1 minute. What is this interim order?
No course action shall be taken.
Investigation is going on.
Lots of.
Huh?
I will take instruction to them.
What stage?
Last of lots of directed me to file charge sheet. I have also filed the same.
You will not file.
Filed the same. That's the sound.
Short date is on request. Huh? Short date.
Tomorrow.
Yes, next.
88.
Yes. Yes.
88.
Yes. Hmm.
88 is also supposed to argue. Lordships may first note some dates, your lordships. Only 15 minutes, your lordship. Lordship, the date of registration of FIR is 9/4/2018. Lordship may note it down.
9/4.
2018.
Yes.
Now, your lordship, the first charge sheet was filed on 28/12/2020. For the offences punishable under 120B, 420, 13(2) and 13(1) of the PCI.
Please repeat once again. First of all.
120B.
No, FIR is
9/4/2018, your lordship.
9/4/18. Huh?
Yes.
Okay.
Now, your lordship's charge sheet was filed both against private person and the bank officials, your lordships, on the complaint of the bank, your lordships, on 28/12/2020.
20.
20, yes.
Yes.
Now, lordship, the second charge sheet was filed.
This is preliminary.
Yes. On 27/6/2022, your lordships.
27/6/2022.
22. Yes.
Yes.
Now, lordship, the date of OTS, which is very crucial.
This is the final charge sheet.
Yes.
Yes.
Date of OTS, your lordships, is before the filing of the first charge sheet.
Yes.
And before the date of sanction order, your lordships. The date of OTS, your lordships, is 27/11/2020.
11/22.
20.
20. Okay.
So the date
before the preliminary charge sheet.
Yes.
Yes.
So after OTS, your lordships, first charge sheet and second charge sheet were filed.
Yes.
The sanction.
Because of that condition, that the
Criminal action will continue.
action will go on. Yes.
If your lordships like to stop your lordship for a moment, if your lordships will come to page 30
Yes.
of my reply, page 30.
Hmm.
This is a letter written to CBI by the bank.
Yes.
And the letter date, your lordships, is 4/2/2020, your lordships.
Yes.
Lordship, may kindly see that the date of the letter, your lordships.
Yes. Yes.
So this date, your lordships, was 4/2/2020, which is 7 months, your lordship, before the date of the OTS. Now, lordships, I would like to read it with permission. The OTS was sanctioned by our corporate office, Bombay, letter dated 27/3/2019,
Yes.
for an amount of 40 crores towards settlement under the OTS, sanction limit of 87 crores.
Yes.
And the outstanding balance amount of 62.4 crores as on sanction date of OTS, with a rider that the criminal action will continue. Now, lordships.
That's the OTS condition. One of the OTS
condition.
condition. Yes.
Now, your lordships, the entire argument that there is a settlement between the bank and the private party, your lordships, any reasonable man, your lordships, would not give sanction to prosecute your own people and tell that the criminal action has been caused against the private individual. Therefore, my first submission, your lordship, is that the culpability or criminality of the commission of the offence, your lordship, doesn't go away with the claim that there is an OTS.
Yes.
Because there is no OTS, your lordship. There is only a settlement.
No, last time we stuck in one point.
Yes.
He relies upon two judgments.
Yes.
Directly covered.
Yes.
On the same circumstances. Saying that once OTS is accepted by the court, in the same breath you can't prosecute.
Yes.
That is what is the argument.
And if I exactly
And then I asked whether in those cases the OTS, whether the similar condition,
I'll come to that, your lordships.
notwithstanding the OTS.
I'll come to that, your lordships.
Yes.
But before that, your lordship needs to understand what is the background of the case, your lordships.
Yes.
I would like to give you a hypothetical example, your lordships. Your lordships, for example, if I go to a bank and ask the bank that you please give me 100 crore rupees, and these are my third party things, you give me.
Yes.
The bank will follow the due procedure and bank will give me 100 crore rupees. So if I tell bank that I am using this money for X purpose, that I am taking the loan, I use it in a particular manner. Then I misappropriate, your lordships. Then I go to the OTS and I tell that you take 40 crores. This is the final settlement. What remaining 60 crores, your lordships, is the money of the taxpayers, your lordships. So every time I can continue with the modus operandi, I can go to some bank manager
And pay the money and get rid of it.
Yes, and every time I can do it.
That's I understand.
This sanction, your lordship, therefore it is necessary that your lordship may kindly come to the sanction order.
Yes.
I'll answer your question also, but kindly come to the sanction order. Sanction order, your lordships, is my annexure 2.
Yes.
This sanction order, your lordships, has my counter.
Yes, I am there. Exactly. Yes. Okay. Yes.
Lordship, may kindly see the date of the sanction order. Sanction order for prosecution of Sri Udaynath.
Yes.
Assistant General Manager, the Central Bank of India, Jamshedpur branch. Don't want your lordship to microanalyze the contents of the sanction order, but your lordship may kindly come to paragraph 6, 7, and 8.
Yes.
The material placed before me, such as FIR, investigation report, and other related documents reveal that Udaynath Giri has prima facie committed offences punishable under 120B, 420, 13(2) and 13(1) of the PC Act. Therefore, I, Smruti Ranjan Das, authority competent to remove the said such and such. Then, your lordships, he has perused the matters placed before him. He has applied his mind, your lordships, and given sanction. Your lordship may kindly see the date of the sanctioning order.
Yes.
The date of the sanctioning order, your lordship, is 22/1/2021. The date of OTS is 27/11/2020.
20.
Therefore, he has given sanction by applying his mind after the OTS, your lordships.
No, on merit I am convinced that the crime,
Now, on
the crime case is there.
Yes.
There is no doubt about it.
If on merits your lordship is convinced, now your lordship may kindly come to law. But before law, your lordships, this company, your lordship, is what is the name? ARSS, your lordships, from Agarwal. If your lordship will go to that area near Jajpur and Bhadrak, all trucks, your lordship will find RSS.
I am convinced that the crime has been committed.
Yes. Now law, your lordship.
Having said that, how will you get over the judgment of writing? That's the only question.
Your lordships on same cause of action, same facts. Last time your lordship asked me, if I exactly remember, he has referred to some B.S. Joshi, some B.B. Agarwal, and one merchant, Nikhil Merchant's case.
Marchand and B.B. Agarwal is directly covering his case.
Yes.
Subject to condition that in those cases also OTS has taken place.
Yes.
And I specifically asked the question in those OTS whether this condition was there or not.
Yes. Now, lordships, I want to give your lordships another comparison.
If this condition was there in those cases also, even then the Supreme Court has quashed saying that OTS has taken place, then I think you have difficulty.
Now, lordship, may I kindly see the date of video program? What is the date?
18 February 19.
Yes.
Well, 18 February 19.
18th February 2019, your lordships.
Yes.
Is B.B. Agarwal. Now, lordships, two bench of the Honorable Supreme Court.
B.B. Agarwal, where is that?
B.B. Agarwal.
You filed the compilation.
But it's a part of my compilation.
B.B. Agarwal, 1 minute. Yes, B.B. Agarwal.
The second judgment in my compilation, my lords, at page 10.
Before he finds out, your lordship, I remember.
B.B. Agarwal is
Justice Muralidhar was
in the High Court.
Coming from the High Court.
Okay.
Delhi High Court.
Now, your lordship, may kindly come to B.B. Agarwal, paragraph 12 in his compilation, which is in page 12.
Yes.
And your lordship knows that the ratio cannot be, your lordship, some random thing can peak to ratio without going into the background of the case, your lordship. The High Court then examined the question whether the issue of criminality is involved. So as to examine the question as to whether any issue of criminality is involved to allow the criminal trial to continue on merits. After examining the issue with reference to the charges and documents, the High Court held that no criminality issue is found out, notwithstanding the settlement, your lordships.
Yes.
Of the case between the parties. Now, your lordship will come to the offences of B.B. Agarwal. At that point of time, your lordship, there was also PC Act involved. But your lordship, I kindly find.
And B.B. Agarwal, the allegations are serious. They are very serious.
But your lordship, I was reading one judgment outside.
But B.B. Agarwal, the offences are more serious. Forgery is there. 409 is also there.
Lordship, this CRLMC number 3407 of 2010.
Yes.
This was your lordship's same Justice Muralidhar's judgment. CRLMC number 3407 of 2010. 2010. But it is not on this.
Delhi High Court.
Lordships, paragraph 24. I would like to read, then I'll lordships come to my compilation.
Yes.
However, as far as this court is concerned, it is not persuaded to adopt the above line of reasoning of the learned judges of the said High Courts of Kerala and J&K for the simple reason that full benches of the three bench, when there is a conflict between two decisions of the Supreme Court of the same bench, it is the later of the decision that would prevail.
Yes.
Now, your lordship, the later decision, which was also given by three bench, not two bench, that would prevail on the same subject matter, and this judgment, your lordship, is 2019.
Yes.
Volume 5, SEC, page 6.
So show me that judgment.
I have given it, your lordship, the compilation.
Give me.
Your lordship has not explained about the.
Taking a contrary view.
Yes. Absolutely contrary. Four judgments are your lordship's clear. I have given him also. We have given a compilation, your lordship.
It's a case of attempt to murder, my lords. Not an OTS case with the bank.
No, the principles are available. Then we'll come to OTS, your lordship. OTS also I have given.
Come to the OTS, why? Where are you going to murder?
No. The question is, your lordship.
What is the principle?
Your lordship can come. State of Madhya Pradesh.
The issue is, if there is a bank fraud, whatever,
your lordship can read it. I'll read it.
and the OTS has taken place, bank got the money, whether after getting the money, whether it can prosecute or not. That's the question.
I'll come to it. But in this judgment, the Honorable Supreme Court is saying that which category of cases can't be compromised and can't be quashed, even if there is a compromise. So even though it was in relation to attempt to murder, the Supreme Court has categorized the cases where your lordship, even if there is a compromise also, your lordship doesn't have the power to quash it, even if it has the power, should not be exercised. Lordship, may kindly come to page 7.
7.
Yes.
Yes.
This is your lordship economic offense.
Hmm.
Wrong compilation. Wrong compilation.
This, you are reading Minakatan part.
No, no, not Minakatan. Lordship, I'm giving compilation.
Where is this?
Out of your lordship.
What? Where are you giving this? This one? Okay. Why you giving it? Huh? Who is referring? Minakatan.
Minakatan I refer.
Minakatan is altogether whether you are exonerated in departmental proceeding, whether you can be prosecuted.
Yes. Discuss your lordships, the later judgment will prevail. Therefore, I give that.
Oh, that is the first principle.
Yes. Now, your lordship, can you come which category of cases can be?
Yes. Show me.
Page 7, your lordships.
7, huh? Yes.
Before that, page 5, your lordship, I'm sorry.
Yes.
Similarly, any compromise between the victim and the offender in relation to the offences under special statutes, like Prevention of Corruption Act or the offences committed by the public servant while working in the capacity, cannot provide for any basis of quashing criminal cases involving such offences.
Yes.
Even though it was in relation to 307, the court is quite categorical and clear that offences under Prevention of Corruption Act, like this case, can't be quashed even if there is a compromise.
My lords may read the next sentence.
Yes.
But the criminal cases having
the criminal cases.
Yes, but the criminal cases having overwhelmingly and predominantly civil in color, which is not here because he has committed offence and there is a committee case pending against him. Criminal cases having
Criminal cases having overwhelmingly and predominantly civil flavor stand on a different footing for the purpose of causing particularly the offences arising from commercial, financial, mercantile, civil, partnership or such like transactions. This is from Gyan Singh, my lords. The next line in Gyan Singh says, having held that Gyan's Nikhil Merchant has been decided correctly, my lords. That's a part of my compilation, I'll show. This para that has been quoted in the previous page, my lords.
Don't go into the first principle. Come to the right point.
Now, your lordships, kindly come to page 51 and page 96.
51.
It's a civil dispute, provisional attachment by ED. At page 96, your lordships is the money laundering case registered against him in the same FIR. That is the predicate offence. So the commercial dispute.
Are you worried about ED case? If predicate commit offence, schedule offence goes, predicate
ED case is pending against him. There is an ECR. He's being interrogated in EC case.
That is a consequential proceeding.
But this
because of the schedule offence.
But that consequential offence, your lordship, there is money laundering, which is a criminal offence, your lordships. Huh?
Yes.
What? Criminal offence. Now, your lordships will kindly come to my compilation. Second one, your lordships.
Yes.
State of Maharashtra versus Vikram Doshi.
Vikram Doshi, okay.
Yes.
Para?
Second last para, your lordships.
Yes.
Full paragraph, your lordships. It is not such a case where no one can pay the amount and
which para you are reading?
Entire paragraph, para 26, your lordship.
26. Para 26, yes.
This is bank and financial transaction. This is not model case. We are in respectful agreement with the view. Be it stated that availing of money from a nationalized bank in the manner as alleged by the investigating agency vividly exposes physical impurity and in a way financial fraud. The modus operandi as narrated in the charge sheet cannot be put in the compartment of an individual or personal wrong. It is a social wrong and it has immense societal impact. It is an accepted principle of handing of finance that whenever there is a manipulation and cleverly conceived contrivance to avail these kind of benefits, it cannot be regarded as a case having overwhelmingly and predominantly civil character. Civil character. The ultimate victim is the collective. It creates a hazard in the financial interest of the society. The gravity of the offense creates a dent in the economic spine of the nation. The cleverness which has been skillfully contributed, if the allegations are true, has a serious consequence. A crime of this nature, in our view, would definitely fall in the category of offences which travel far ahead of personal or private wrong. It has the potentiality to usher in criminal crisis. Its implications have its own seriousness, for it creates a concavity in the solemnity that is expected in financial transactions. It is not a case where one can pay the amount and obtain a no due certificate and enjoy the benefit of quashing of criminal proceedings on the hypothesis that nothing merely remains to be done. The collective interest of which the court is the guardian cannot be silent or a mute
Yes.
spectator to allow the
I
proceedings.
got it. Next. Ready.
This is in our favor, your lordships. Now, your lordships,
On merit, this is in your favor. I'm with you. I'm saying that the crime has been committed. But now he's in
now
some
your
other
lordship,
point.
can come to page 22.
You come to that point first. I'm convinced that the crime has been
Your lordship,
committed.
Prevention of Corruption Act cases cannot be quashed. Even if
You show me that.
Yes.
Even if in these circumstances it can't be.
Yes, I've come to it, but where it is discussed, I'll show, and I'll show you a direct judgment of
Yes.
your lordships.
Show me that.
Lordship, can you come to page 22?
22 of
22 of my compilation, the penalty.
Ishu Narang.
No, Ishu Narang, I'll come, your lordships.
Yes.
This is Vikram Doshi.
Vikram Joshi, I read it. Ishu Narang, come.
No, page 22, I'll read it and I'll come to Ishu Narang.
I read that also.
Any compromise between the
You
victim
can
and-
see and I've understood. Come to issue. Come to issue. I've read it. Don't waste.
Yes. I'm not used to it. Issue
Come to issue.
Issue Narang, your lordships may kindly come from paragraph 22.
22. Okay.
Issue Narang, your lordships is 22/11/2020, your lordships.
Issue Narang para 9.
Para 9, your lordships.
Yes. Contention recorded. Read para 9, then 22.
Yes, your lordships.
Yes.
Para 9, I have read your lordships.
Yes.
I'm coming to
Come to 22 now.
22.
Yes.
Para 9, where his arguments.
Yes.
The petitioner.
Yes. Then I come to 20.
There are 3 letters. As in this case, there is also a letter.
Yes.
As discussed in this letter, such and such, both the banks have informed the petitioner that acceptance of OTS will
Yes.
not absorb the criminal proceedings and criminal.
Come to this is relevant. Yes.
Yes.
Come to this point. Yes.
Same thing, your lordship. What
Yes.
in this case?
Hmm.
Should I read more?
Yes, you must read this. This is
Both terms and both are different.
this is the relevant point.
Yes.
The rest of it.
It appears that the said terms and conditions are not there in respect of the company of Sadhuram, the judgments which others were showing. This particular thing, your lordship.
But this is Telangana.
This is?
Telangana.
Yes, your lordship. Then I can come. Supreme Court judgments have been discussed, then we'll come to Supreme Court. Para 24, your lordships.
Agrawal is noticed in this case?
No.
Para 24, your lordships.
Not noticed.
Agrawal is not noticed.
What is noticed is Sadhuram Singla
Your lordship, I will
and
come to the Supreme Court, which is after Agarwal, in which these things have been discussed. And the second judgment, your lordship has to appreciate because it came later on. Therefore, I gave the first judgment.
The Telangana is covering your case.
And again, come, your lordship, to the Supreme Court.
Yes.
Lordship, page 24.
Yes.
The mere fact the banks are already under stress to clear the NPS from their books accepted the OTS will not absolve the petitioner from criminal charges.
Yes, you are right. Here you are covered.
In the said letters, both banks have specifically mentioned that acceptance of OTS proposal by the banks will not absolve the criminal liability. The
Yes.
source of fund used by the petitioner for the completing the OTS is also suspect, and it is a part of ED's fund trial investigation. Therefore, I was.
You are directly covered there.
Therefore, yes.
Yes.
Directly covered.
Come to next judgment.
No, your lordship, the page 32 Supreme Court judgment is discussed.
32.
So, yes, para 32, page 40. There is a Supreme Court judgment which is discussed, even if it is a Telangana High Court.
16.
Page
2016.
40, para 32.
Agrawal is not noticed. That's the problem.
Yes.
Otherwise, you are directly covered.
No, your lordship, this is Supreme Court judgment, your lordship can
But
directly.
Agrawal in 2019 not.
After Agarwal.
This is yes. This is 20 judgment.
Yes.
Agrawal is not noticed.
I'll come to
2016 judgment is
Agarwal.
you are directly covered by this judgment. I understand that. Yes. Come to the Delhi wala judgment.
May come to Punjab and Haryana High
Yeah,
Court.
Punjab Haryana. Yes.
Your lordship, without observing Agarwal, a state High Court, your lordship will not go against the Supreme Court. Therefore, the Agarwal has been discussed. Your lordship.
Agrawal might have been escape notice of the court.
Lordship,
That's what I'm saying.
Can you come to this judgment? Lakshmi Narayan said,
It is 307.
no, 307, your lordship, kindly see the principle which is discussed. Where it has been referred to your lordship 2017 volume 4 RCR 523 Supreme Court, which are the category of cases, your lordships, where your lordships can exercise your power. Lordship may kindly come to page 48.
Yes.
I'm discussing the principle, your lordships.
Yes.
Your lordships, economic offences involving the financial and economic well-being of the state have implications which lie beyond the domain of a mere dispute between private disputants. the High Court would be justified in declining to quash whether the offender is involved in an financial or economic fraud or misdemeanor. The consequences of act conflict on both the financial and economic system. Therefore, your lordships, economic offences can't be quashed. And the offences under Prevention of Corruption Act, your lordships.
Where is the judgment? Prevention of corruption? Come what may, it can't be quashed.
That your lordships have shown the state of Madhya Pradesh versus Lakshmi Narayan. It is clear, your lordships.
Yes.
Para 29.3.
29.3. Yes.
At page 12, your lordships.
Such a power.
Page
29
12, lordships. Para 13, page 12.
Page 6. Page 6.
Page 6 and page 12, para 13.3, Roman 3, your lordships.
Yes.
Not to be exercised. The language is not may be exercised. Or should not.
Not to be.
Similarly, such power is not to be exercised. For offences under the special statutes like Prevention of Corruption Act. All the offences committed by public servants while working in that capacity are not to be quashed. Merely on the basis of compromise between the victim and the offender. So nothing can be more clear than that, your lordships. And when the principle is clear, your lordships, whether the BB Agarwal has discussed or not, your lordship, doesn't matter, your lordships. It's a 3-bench judge, your lordships.
Yes.
And the date, your lordships, is I think 1 month after BB Agarwal. The date, your lordships, here is 5/3/2019. BB Agarwal. February, your lordships. This is 1 month after that. 3-bench.
Yes.
Agarwal 2-bench. Parallel judging.
Yes, anything?
Bank's counsel, your lordships, is not here. Bank should have said that whether
Bank is happy by taking money.
Bank is happy.
Your lordships, I'm on VC, your lordships.
Bank has taken money.
Bank has already taken the money with that rider that prosecution will go on. I'll take my money and go out.
Not the entire money, your lordships. I've taken part of it. The loan was given without any.
Part of it, but OTS, you have agreed to that. And because of that condition which is there in OTS, he is facing it. Now he is relying upon a direct judgment of Agarwal and other judgment.
I completely rely on Mr. Naik's judgment. He's given whatever he has placed. I've noted on, of course. So I'm going to.
Now answer to that how to get out of Agarwal. This is what you want to say, that a subsequent judgment of same strength will prevail.
But it's a larger bench also, your lordships.
Same strength, it's largest three judges bench prevails. That's what you say. Yes.
Your lordship, this judgment is also very nice. If your lordships, 2014 volume 15 SSC page 29.
Yes.
State of Maharashtra versus second last. This is Honorable Justice Mr. Deepak Mishra's judgment, your lordships. 2014 volume 15 SSC page 29. Same thing, your lordships.
Yes.
Same OTS, same compromise. Gyan Singh discussed. Nikhil Merchant also discussed. Yes, your lordships. Lordship, kindly come to pen for 2 minutes with me.
Yes.
Page 21, para 14, your lordships.
21.
Page 21, para 14. Rumita.
Yes.
And Nikhil Merchant also discussed, your lordships. In para 22, it is a well settled principle of law that in case.
Where are you reading? Para 14.
Para 14, where your lordship Duncan Agro and Nikhil Merchant has been discussed.
Nikhil Merchant is noticed.
It is now a well settled principle of law that in a given case, a civil proceeding and criminal proceedings can proceed simultaneously.
These are first principles.
Bank is entitled to cover the amount of loan given in the if in connection while with obtaining the said loan, criminal offences may have been committed by the person accused, including of offence proceeding also induced maintainable, your lordships. In the said case, court took note of the fact that compromise entered between Oriental Bank of Commerce and the accused pertaining to the repayment of loan could not form the foundation of discharge of the accused. The two judges appreciated the stand of CBI before the High Court that criminal case against the accused are started only after obtaining the loan, but also on the ground of criminal conspiracy with the bank officers and accordingly upheld the order passed by the High Court. Nikhil Merchant has been discussed, Your Lordships.
Yes, Mr. Khanna.
Yes, my lords. I'll just take 2 minutes, my lords. First, my lords, I'll just take my lords.
Nikhil Merchant, the same condition was there.
And BB Agarwal has followed Nikhil Merchant, Your
So,
Lordships.
my lords, none of the cases, Nikhil Merchant and BB Agarwal have not been overruled. They're still the good law, my lords.
But the highest, biggest strength.
Yes.
No, my lords. No, my lords. In state of Madhya Pradesh versus Lakshmi, Nikhil Merchant has not been discussed. That was Vikram Anand.
I am not on that. I am not on that. I am on the first this judgment. This is the 2000. No, this is 2014 judgment.
2014 judgment. BB Agarwal came in 2019.
We have to answer that Prevention of Corruption Act cases can't be quashed even if there is a compromise.
Vikram Joshi has held this.
Yes,
but thereafter BB.
It is distinguished upon facts.
After that, Your Lordship,
BB Agarwal has come in February 2019.
Your Lordships, he has to show a judgment that this is, Your Lordships agree that this is an economic offence.
Yes, yes.
An offence under PC
On
Act.
many time with you, I am saying.
PC Act also. The Supreme Court is saying that it can't be quashed if there is a compromise. Then therefore, he has to
Let me show it in PC.
Yes.
Yes.
That's where the Agrawal judgment comes.
Yes, my lords, may kindly have my compilation for a moment.
This judgment which I showed you, Lordships, is after Agarwal's judgment.
See,
one more after that.
No.
Yes.
Come to
That's a attempt to murder case.
Come to Agrawal.
My lords,
No, I'm not confusing.
You read out
Lordships, for a moment, forget about OTS.
You read out Joshi, which is 2014 judgment.
But after that, Your Lordship,
And he is relying upon 19 judgment of Agarwal.
But Your Lordship, this 2019 judgment,
Yes.
which is a 3-bench, it is saying that it can't be quashed. In PC Act, what is the answer to that, Your Lordships?
I have an answer to that. Yes. I have an answer to that. Now, as we kindly see in my friend's compilation itself, the 2019 judgment, which he says is later in time. Now, as we kindly see para 9.1 at page 4 of his compilation.
Whose compilation?
Now, it's Mr. Sarthak's.
Yes.
Now, as we kindly see para 9.2.
9.2.
Yes, Where this Prevention of Corruption Act point is coming from. Well, kindly see, in the case of Gyan Singh,
yes,
para 9.2 at page 4. In the case of Gyan Singh, in paragraph 16, this court has observed and held as under, and then Malo straight away over the page, this line comes, 4th line from top, page 5.
Yes. Similarly,
any compromise between victim and offender in relation to the offences under special statutes like Prevention of Corruption Act or the offences committed by public servants while working in that capacity, etc., cannot provide for any basis for causing criminal proceedings involving such offences, but the criminal cases having overwhelmingly and predominantly civil flavor stand on a different footing for the purposes of cautioning, particularly the offences arising from commercial, financial, mercantile, civil partnership or such like transactions. Now, my lords, may kindly see Gyan Singh itself. My lord, may kindly have my compilation for a moment. Because I want to show what is the next paragraph of Gyan Singh.
Yes, Gyan Singh there.
My compilation, my lords.
Yes. Para?
Yes, my lord. I'll just point out para 61 at page 100.
Gyan Singh.
Gyan Singh in my compilation.
Yes.
Page 100. Nikhil Merchant was referred, my lords, to 3-judge benches. What is the context of Gyan Singh? I'm just pointing out. My lords, a 2-judge bench had referred Nikhil Merchant to a 3-judge bench to see its correctness, to test its correctness.
Yes.
Now, please see para 61, which starts at page 99 of the compilation.
I'm there.
And then page 100. This is the para which is
the position that emerges.
Yes. Page para 62. After
61, the position that emerges.
The position that emerges. I'll just read.
Can be summarized.
The position that emerges from the above discussion can be summarized. Thus, the power of the High Court in quashing a criminal proceeding or FIR, a complaint and exercise of its inherent jurisdiction is distinct and different from the power given to a criminal court for compounding the offence under 320.
320, we say is 482.
482.
62.
Mallards. Inherent power is a wide plenitude, no doubts, Mallards there.
Yes, Nikhil Merchant.
In what cases power because criminal proceeding or complaint or FIR may be exercised by the offender, so and so. My lords, may at next page, Placitum B.
Yes.
We read the Prevention of Corruption Act, my lords, next to Placitum B. 100 of the compilation, Placitum B.
Yes.
This is the line which has been quoted in the 2019 judgment, which my friend was showing in this compilation. The Prevention of Corruption Act or the offences committed by public servants while working in that capacity as a cannot provide for any basis for caution criminal proceedings involving such offences. Both the criminal cases having overwhelmingly and predominantly civil flavor cannot then para 62. Please see.
60?
No, next para.
Yes.
In view of the above, it cannot be said that D.S. Joshi, Merchant and Manesh Sharma were not correctly decided. And Nikhil Merchant had PC Act. Nikhil Merchant had PC Act, my lords. I'll show the offense. Yes.
I understood.
But on the Telangana High Court judgment, it has not noticed BD Agarwal, my lords. I must point it out.
Five-year compilation.
My lords. Can I file a written submission?
Both of you filed
written submission.
Was supposed to say something in Lordship, sir.
Bank will also file written submission.
Lordships, I'll file it.
Bank says that I have not received full amount.
Lordship, I quoted some other
Bank said I have adopted Mr. Sarkar's arguments.
How much time I've given? Just 55 minutes.
Was your Lordship, bank will also.
This is a matter of 10 minutes.
Your Lordship, bank will only argue whether they are.
The only legal issue. You have to answer that, that's all.
I will find this time to file the written submission.
File submission, I'll take it, and bank is also entitled to file. You can also file a written submission.
I'll file.
Some direct judgment where it says that there is a completely what do you call the PC cases and completely be there is a bar.
Yes, sir.
There is a bar of quashing.
Yes.
You can get them.
And I just wanted to conclude. Gyan Singh is 3 judges. Nikhil Merchant's correctness was referred.
Thereafter, Madhav Rao Sindhya is also there. B.S. Joshi.
So
many things. Yes.
Pardon me, Lord.
1 minute. Let us.
A minor and a student. He has been falsely pleaded in
Which matter?
105. Only supplementary. After the university said that positively to be taken up many.
105.
On the date and time of occurrence, he was admitted in hospital. He was neither commission of any offense. And so,
what do you want? I can't hear it. Just
yes, I don't invite you.
Come to the point. What do you want exactly? I'll hear you. Let it be there in the list tomorrow. Just
according to make an issue.
I give number 90.
See, wherever whoever wants time, he can.
Last 2 occasions, your lordships remember, I have mentioned in the last occasion.
As the problem is one matter is stuck, then what to do? There in the list. Continue. All the list.
My lord, item 156 of the main list.
So that convenient for all.
My lordship, item number 93.
My lord, item number 105.
We are going to
specific urgent matters are there tomorrow. He says how many? 70 specific urgent matters. How will I go?
Item number 102.
My lord, item number 93.
The state is containing and the complainant is the handicapped person. She is sitting further questioning at this state. I may pray tomorrow 108.
Tomorrow I told you how many matters are listed.
They are
not possible.
At least they have
109 also.
Just see 4:30 till 4:30, 45 minutes I heard one matter. One matter gets stuck. I can't help it.
କିଛି ଶୁଣନ୍ତୁ ନା